Kind of next week, my lord, 20th.
We'll see.
Pardon to
Yes.
make a mention, the matter was specifically adjourned to 10 January, my lord.
Give the
Implement under section 390.
give the memos, we'll check it up.
I beg pardon, your lordship.
Yes.
My lord, item 30, my lord, not pressed.
Wait, page wise you will call. Yes.
Yes, sir.
Any out of list mentioning? Yes. Any out of list mentioning? No? Yes.
I beg your pardon to mention, Mulad. I
Yes.
beg your pardon. Mulad's item number, CRLMC 1659 of 2024. It was specifically adjourned to dated 10th of January 2024 by a lordship. It was supposed to be listed on that day, and it was not listed. 1659 of 2024 CRLMC. May kindly be listed tomorrow if possible, Malads.
Yes.
Much obliged, Malad.
Yes.
Item 1 to 5.
But item number 5, here it's a matter of compromise. Your lordship had permitted both the parties to appear, but my client could not come today.
Okay.
Can it be?
2 weeks. 2 weeks.
Continue.
Okay. Entry mode to continue.
In my
Yes.
first matter, there is no entry.
Okay. Second matter, entry mode. Yes.
Item 6 to 17.
The lordship, item number 7 may be taken
Yes.
up after next week, may be taken up next week.
Next week, you union
The Union of India.
Okay.
We are the
on request of counsel for the petition. Yes.
Item 18 to 33.
Item 20, I prayed for an adjournment, my lord. Item 20.
13
20.
20. Okay. Belgium. Why are you? I'll allow it. Wait.
This matter was earlier disposed of by Honorable Justice R.K. Patnaik below. CRLMC asthila.
I may allow it. Wait. Wait for it. I may allow it. Wait. Yes.
I beg pardon, your
If it is,
lordship.
if it has something, then I'll adjourn it. Otherwise, if it is to be allowed, I'll.
It's clearly instructed me that though the matter has already been disposed of by Honorable Justice R.K. so kindly mention it before the Your Honor's court.
Mark on. Okay.
Oh, bless you.
Item 34 to 41.
May I please, your lordship, my lord, item 30.
Yes. 30.
My lord, I want to be not pressed, my lord.
Not press. Not press.
Blessed.
34 to 41. 42 to 48. 49 to 55. 56 to 62.
Item number 60. There are senior advocate Mr. Ashok mounted requested for next week.
Adjourn on this.
Entry model.
60 na 60. Oh, there is entry model.
Next week. Immediately.
So already take 2017 matter.
That is a personal difficulty. That is why.
Yes.
63 to 70.
Milords, item 60, Milords. Milords, I am being led by Mr. Kanungo, Milords. I have some personal difficulty today. I have come for my grandmother's shraddh to my village. Milords. I could not instruct him. I am
Item
praying for
60.
him.
Which
66,
item?
Milords. 66, Milords.
66.
Milords,
Yes.
I could not instruct him. He is not there also in the town, Milords. So,
Adjourn. Okay.
Milords,
Okay.
there is an interim order. That is the only whole problem.
That's the reason you are asking for adjournment. That's
No,
the
no, no,
reason you
Milords,
are
short
asking
date.
for adjournment. I know.
I'm rather praying for short date, Milords.
All right.
I
Adjourn.
have a good case, Milords, in this.
Yes.
66 Milords. You must do that.
71 to 80.
Lordship, in item number 76, calling for a short adjournment. Lordship, interim order is also there.
Sufficient. Wait then, na? Tick mark. Yes.
Lordship, interim order is there.
We'll see. Sufficient. Notice is sufficient. Let us see the other side comes. Yes. Next.
One.
Sir, my lord, my account has been decreased by the opposite party number 3.
By the OP number 3,
By the opposite party number.
considered your lordship is directed to obtain instruction. He has sent his instruction without specific instruction that whether that can be decreased. But he has stated that privacy is matter, so I have to take instruction specifically.
Lordship, kindly see the last 2 orders.
In this time,
May, my lord, Monday, my lord,
Monday asked it.
that's the
Monday नहीं देखी करी. short date. Okay. Mr. General and Counsel for the state submits that although he has received the instruction, but the instruction is not satisfactory or specific. Therefore, he seeks one more. Yes.
Item 2,
My lord.
Yeah.
Petitioner are convicted.
But in this case, he is already admitted on bail, my lord. Equation copy has not served, it is a final hearing, my lord.
Final hearing matter.
My lord.
But
No.
I have filed IA for stay of the penalty man 500.
No, this is criminal revision or criminal revision. I'll say it. Realization of I allow application. Which is that application? 2915.
My lord.
For the reasons stated in the application, the same is allowed. The realization
Bail
of fine
hearing.
amount.
Bail.
Realization of fine amount is paid. Yes. For 500 you are coming.
My lord.
Yes. Release the matter for final disposal.
item 3,
Item number 3. Lordship, sir, please to direct my friend to file an affidavit. My friend has come difficulties. He was saying that affidavit is not ready. They have not yet filed the affidavit. One thing I may request my friend to take instruction, because I filed an affidavit saying that some sale deeds have been executed prior to date of check period. So my friend may take instruction on that score only. If that comes below the 100%, then the circular of their 4 of 2015 will apply to my case.
You want me to conduct a full trial?
No. Let them. I'm not saying your lordships. Let them file that.
In the investigation, you might have done it already.
The sale deeds are public document. Image of sale deeds.
This has been disposed of during the check period. That has not been considered. Now, my similarly said that should be, because it's a public document,
Yes.
then that should be considered.
But investigation they have not considered.
Who will consider now?
Business.
Who will consider? That's the question. You have filed the charge sheet, you can't consider it. And 482 court can't do it. Then who will do it?
No, 482.
File reply. See.
Let them find out whether the documents I filed are genuine or not. Because I am
Fine. Yes. Okay.
item 4,
short date maybe.
Yes.
item 4,
Discharge application has been rejected.
Item 4.
Yes. Kindly have a glance to page 68. What is the reasoning given by the Land Trial Court?
60.
68. No reason has been assigned. He discussed my case. Land Court will discuss the other side case. And reasoning will also kindly para 6. Page 68. And the order starts from page 59.
What he has considered all the judgments and all. Para 4.
Malad?
Para 4 this thing.
That is the case of the other side. That's from para 3. What is the case of land PP? Land Court will have started from para 3. 1 to my case. 3 to 5 land PP's case. And reasoning is para 6. And this is a discharge, valuable right of the accused.
Yes.
So with that aspect, you lordship can page 69.
Yes.
Yes, I have given.
Para 6, he says that material is there. Your complexity is.
Can it be? When also kindly see the page 67. Land Court will have quoted the judgment. Malad, kindly see. Land Court will have quoted the judgment while discussing the disposing of the discharge application.
May not be happily worded, but the fact remains that he found that the prima facie case is made out.
Your lordship can see para 6, page 67.
60?
67.
Okay.
Guidelines has been quoted. What are the guidelines Honorable Supreme Court has fixed for disposal of 227 application? And you'll also kindly see, para 6. At the stage of section 227, 228 CrPC, the court is required to evaluate the material and documents on record with a view to find out the existence of all ingredients and constituting the alleged offences. And interestingly, what are the allegations against me, my lord? But I am the secretary of the Urban Cooperative Bank. Now, my lord, Vigilance Authority has come. My engagement is illegal. The government has, my lord, appointed me as a secretary of the. Can the Vigilance Department will lodge a criminal prosecution? Why the government appoint me as a secretary of the Urban Cooperative Bank? If this is the case,
Show me the
you will also kindly see the FIR itself.
allegation. Let us charge sheet. Come to the charge sheet.
Kindly see the FIR.
Can I come to the charge sheet now?
Well, page 26, you will also kindly see.
Charge sheet, come.
No, FIR itself.
After investigation, charge sheet.
Yes, my lord. Kindly see the charge sheet also. Well, para 2 will also
You have
start from
disbursed
page
10
38.
lakh rupees you have disbursed in favor of some Naresh Chandra Mahapatra.
Yes, Loni has,
Accepting
Loni has
It is
taken
not
the loan.
regarding appointment. It is regarding the wrong disbursement of 10 lakh rupees.
No, but against me, that is not an allegation.
First paragraph.
You will also kindly
On the
see.
allegation
This-
of the accused, the public servant Bharat Jagdev, in corruption with Naresh Chandra Mahapatra, so and so, and in prosecution of the conspiracy fraudulently sanctioned and disbursed 10 lakh rupees during October 2022.
Yes,
That
the
is-
loan is granted to somebody
But it
else.
is nothing to do with your appointment.
No, I am no way connected to that loan.
That
That's
will be tested. That's a different story.
that is the entire case, my lord. A prosecution allegation, there were 2 allegations against me. One is government has illegally appointed me as a secretary, and second allegation that I have not furnished the appraisal note. This is the 2 allegations against me. But a concerned branch has granted sanctioned loan. Why the secretary sitting in the head office? Nothing to do with the loan. The lord, can you see?
Just see
Lord, can see.
page 38, last paragraph.
Though while commit management consisting of elected board of directors of the bank was dissolved, Sri Bharat Bhushan, myself, my lord, Sri Bharat Bhushan Jagdev, such and such were appointed secretary and management of the bank respectively. Obviously to look after only day-to-day affairs of the bank, but fraud perpetrated when on 21/2001 vigorously both of them dissolved the meeting of the
Resolved in a meeting
sanction loan.
to sanction.
Yes, secretary is not.
Board was dissolved. You were caretaker and you were sanctioned loan. And that is the case.
I may be.
Yes.
Here, board of directors is there. Board of directors is empowered to sanction loan. The only secretary plays the file. This is the entire case.
This thing here.
So role of secretary is very limited. He will place the file before the board of directors. Board of directors will sanction the loan.
See page 40. Page 40 also, just see.
The case is that.
You are responsible, sir.
I am not responsible.
But from office there is case. So I think you should proceed. Please the trial. Yes. Anything else?
The loanee has taken the loan and he has cleared the entire loan amount. Bank has earned profit. There is no loss to the government.
Where is that? Bank has earned.
That is my. I have heard that.
No, very in the charge sheet. What have you done? That's more important.
No, I have not.
Without collateral, without anything, you have sanctioned 10 lakh rupees and disbursed it.
My lord, kindly
without
see
authority.
my petition. Kindly see my discharge petition will also have a glance. I have given elaborately.
On the basis of pleading, though, I can't decide, na?
No, that's at 227. But in the other hand, my lord, kindly consider.
Only
in a 227
just see the charge sheet. Whether prima facie case is made out or not, just check it out.
Correct.
Prima facie case is made out. Your discharge application is disposed of. Maybe it is not happily worded.
No,
but
not
the fact remains that he says that material is there, and I am satisfied that
Then-
complexity is there.
if every application, if magistrate will say, I am satisfied with the plot.
No, he discussed, he took into consideration your argument, the prosecutor's argument, and thereafter, in the concluding paragraph, he says that
There is a prima facie case. There is is it the way to dispose of my application? But learned trial court has elaborately discussed what are the guidelines fixed by the Supreme Court while disposing of my application.
Show me the guideline.
That will also be kindly see. These are the guidelines.
6.
Para 4, my lord. Para 4, page 66.
6. At the stage of 227,
No, no,
28 CrPC,
No,
the
my lord.
court is required the material
Yes.
and document on record
Yes.
with a view to find out the existence of all the ingredients constituting the alleged offence. But the court cannot be expected to presume that the prosecution story is gospel truth. This is what is there. Last.
My lord, regarding the acquittal of the principal accused, I am hearing, my lord, file here with the copy of the judgment, in which, my lord, the principal accused, and I am supplying the copy also to my lord in state counsel, my lord, that here, my lord, earlier this present petitioners filed the application before this honorable court, and this honorable court was pleased to direct this present petitioners to renew my prayer further before the Lorraine court. Thereafter, my lord, these present petitioners.
You have been absconding.
No, my lord, no, that is not.
2014 FIR, why the other accused persons face the trial? Where
No, I am not at all unaccused, my lord. I am not.
Said last occasion directed to file the charge sheet because the court, while dealing with the matter, has observed that since the investigation on the section 173(8) is open against the persons who have also conspired with this principal accused, or he has actively participated. He has not filed. Now, just now, he has filed the copy of the judgment. That is,
where is the charge sheet then? Show me the charge sheet. Charge sheet has been filed?
preliminary charge sheet has been filed.
No, no.
Also, directed.
My lord,
Where is the charge sheet?
my lord, it is a case of the year 2000.
Show me the charge sheet.
Charge sheet, my lord.
2014. You file all these things. Don't give all these things.
File. My case is,
You
my lord.
please file everything.
Yes, my lord. My lord.
Yes.
My
Then
case.
also for the petitioner seeks to file the additional document to substantiate his case. Let him do so within a week. Leave the matter. Yes.
My lord, I pray I already hand over the
Whatever document you want to file, file it. Because
I have
now
already-
giving it in the court, that is not permissible.
My lord, I pray for a short time, my lord.
No, he will
Because
give it.
short
You should have done it. Why unnecessary
Because
wasting
my
time? I don't know.
class has-
You are holding it in your this thing.
my lord.
Why for you have kept it?
Instruction was called for to obtain.
नहीं नहीं इंस्ट्रक्शन on record
ठीक है, हम दे देंगे। मैं prayer
We will see. How can we adjust?
खाली short date का वो 6
We,
लाख टका
I
पड़
just,
गई।
yeah, how can we adjust you? You have wasted your time.
आ गया।
Yes, next.
8.
8.
There is a case, my lord. In 2011, there is a disproportionate asset case was registered against the petitioner.
Yes.
Then it was investigated. Final form was submitted that no case was made out. Then the court reverted back for re-investigation. Then it was re-investigated. Again, the report come, there is no case to be made out. Then the court took cognizance. High Honorable Court. This Honorable Court quashed it. They didn't challenge, the vigilance didn't challenge. Now I ask for return of my seizure document. That is to be returned to me because my passbook, and they have, the court has directed, your lordship, can you turn to 12? Court paragraph.
Para 3.
The,
Now they are then maybe so.
that is an undertaking I have to furnish to take back my own document. That is what I'm challenging.
Consider it then. What is the problem? Why is not that all?
Undertaking that's what I asked.
Why he has been there and everything? Why should he give undertaking? You have been, the closure report has been filed.
Closure report
twice.
Yes.
Twice.
Twice. And then the cognizance was taken, the cognizance was quashed.
Have you given the date chart?
Yes, madam.
Yes, right. Petitioner is agreed by the order dated 16/5/2023 passed by Lieutenant Special Judge Vigilance Cuttack in criminal MC case number 5 of 2023, whereby the application moved by the petitioner 452 CrPC has been turned out. Mr. Rathod and counsel for the petitioner submit that initially the trial court took a trial court by order dated 21/6/2022 to cognizance of the offences punishable under section 13(2) read with section 13(1)(e) of PC Act against the petitioner emanating from VGRS number 64 of 2011. This court, while this was we said the order was assailed by the petitioner, and this court, while allowing his prayer in prayer by order dated 6/1/2023 in criminal MC number 3901 of 2022 was the cognizance order. Was the cognizance order. The matter was twice investigated, and thereafter the cognizance order was passed, and subsequently this on the intervention of this court, the cognizance order has been passed. Hence, the petitioner.
This order was done despite permission of final report twice.
Yes, say that, sir.
And filed closure report by the investigating agency. Despite that, the trial court had taken cognizance on the intervention of this court, the cognizance order was cast. Thereafter, the petitioner moved application. Where is that application, sir? Application, impugned application.
Annexure 3, my lord.
Seeking what? Seeking the
page
release for the documents and the articles seized from the petitioner during the investigation. The said application has been turned down by the trial court by the impugned order. Mr. Maharana led counsel for the vigilance by pointing out to para 3 for the impugned order stated that at the stage during before the trial court even the vigilance had no objection if the application would have been allowed. Para 3 for the order reached under. The trial court has rejected the
not rejected.
Trial court has although allowed the application, but with the condition that the petitioner is required an undertaking to the court. Undertaking to the court. What kind of undertaking? It's close. Undertaking to the court.
To produce the document and article if required and directed by the court.
Pass the following order. Para 12. Petition is agreed by the condition imposed by the trial court to furnish the undertaking. Hence this petition. Regard being had submitted by both the parties, the bar, and the fact that the vigilance has no objection for allowing the application under section 452 CrPC by the petitioner, and the fact that the vigilance after investigation filed closure report by short, and this court had already was the cognizance order, which has attained finality. I am inclined to allow the petition directly. It is under your position. It is in your position at the court.
Police.
Ayo pakar thiyo kare? No, he might have filed in the charge sheet, na?
Malkhanar.
Whom shall I direct?
Ayo be directed, my lord.
Direct, so you have to give a direction, otherwise he will be in.
Ayo, my lord.
Ayo, okay.
Ayo.
Then don't move application subsequently. Modification, huh?
My lord, I will not.
Because in the charge,
I have prayed for
along with the closure report, he might have filed it. Therefore, I am saying.
No, my lord, it was not there on record. Therefore, I have prayed before the court below to with a direction to the.
How you would retain it? Yes, file a report under 173. He has to file all the documents.
The closure report has filed.
Still, the documents has to be filed. He can't retain it.
But the document list, it is written.
I can write IO, but I have all doubts. Right. That is to the IO of the present case to written and all the documents and article seized from the petitioner during the investigation without investigation.
Obliged.
Allowed, yes.
Item 9.
My lord, they can be possible.
Pass over, okay.
So 10.
Ten, your lordship. Matter relating to the MLA lordships, this specific bench is your lordship there, your lordship.
This is not regarding, my lord, may just see.
May notice of the court, your lordship. There is a designated court, your lordship, sitting MLAs, MPs matters are heard by this honorable court and another bench, your lordship.
Oh,
Yes,
okay.
your lordship, that
It'll go to.
But he's not filing this, he's not, first of all, he's not an MLA, he's an MP.
Yes, MLA, MP is
MLA
bench is there.
assigned bench. Assigned bench subject to police.
My lords, here the problem would be that the date is fixed to then let them not proceed further.
Least it Monday.
17th, this is listed on 17 before the court below, warrants will be issued.
I can't do it because it's not.
Then my lord may request the registry to tomorrow, my lord. The urgency is
I
that.
can't give direction.
My lord, he say that he's a MP, he's Cuttack MP. He would be now hauled up, my lords, by the court.
I understand, but the problem would be I can't give it direction.
All that we want is let it be placed tomorrow, my lord.
Yes, he will do it. Don't worry. He'll do
My
it.
lords, may I submit one thing?
Tomorrow? I'll not give direction, but make sure that it.
My lord, the urgency is this.
I understand it. I'm doing it without passing an order. Let's speak to DR and get it listed. Okay.
Otherwise, elderly man would be hauled up before by the court.
I understand. Lead tomorrow. And your instructing counsel should follow it up.
My lord, we will do.
I'm sending the file right now
My lord.
to the DR and I will do it. Yes.
Item 11.
My lord, item 11 along with item 56. Parties are coming, my lord. They're taking the passover.
Okay, pass over. 11 pass.
56. 11, 56.
12.
So what's it?
Item 12.
May I please, your lordship?
Yes.
As the PC, yes, here is working as a.
First time insert. Yes.
Around next week. Next.
It give a date.
13.
May I please, my lord? Yes, CRLMC related to release of the vehicle implicated in the NDPS Act, my lord. And very recently, lordship has, while observing a case, this order has passed, my lord. Relying the Supreme Court judgment recently. And that is also applicable to this case, my lord. No.
You are the accused.
My lord. My lord.
Where is the order? In order.
Order, my lord, that is 18 and 19, my lord. What's lordship in
What the trial court says.
What lordship quoted in the paragraph 2, that is lordship's order. It is also same, my lord. Page 19.
Ultimately, what does it say? Oh, he says that it's not moved by the investigating agency. He says that it's not moved by the investigating agency, therefore we can't do
Yes,
it.
my lord. And lordship also observed that, my lord. In paragraph, Seder Jaha prayer, enter with what the lower court hold, that is also same.
Petitioner rejected by the order dated 29/7/2024, passed by learned SDJM Koraput in MC number 66 of 2024, whereby the application moved by the petitioner under section 457 CrPC for release of what?
Car, my lord.
Release of
Hon'Ble
Verna, car bearing number so and so has been turned up. Petitioner is one of the accused.
Yes, my lord.
petitioner is one of the accused in the FIR number, PS case number, Padua, dated Padua 338, what is that? Padua 38 of 2022. Padua the PAD, Padua 38 of so and so. Under section 20B2 of 50B of NDPS Act. He is the owner also. He is owner of the vehicle. The next paragraph, the application of the petitioner under section 457 CrPC for release of the vehicle employed, which was employed for the commission of the offence under NDPS Act, as mentioned above, has been turned down. The court below has given the following reasoning. Where is that reasoning? Reasoning is that
Paragraph page 19 below. Paragraph 6.
19, last paragraph. In the that means this section. That means that section. Take it. The sole ground of rejection of the application is that since the application has not been moved or initiated by the prosecution or the investigating agency, the claim cannot find favor from the court. The trial court has relied upon the judgment of
CRLREV 404 of 2020.
The judgment of this court in Mr. Party para 4 भी कर दो, ठीक है, para 4 para 5 भी कर दो, 6 भी कर दो, 7 change कर दो, ठीक, yes,
Item 14.
May I please?
yes,
But this is arising out of matrimonial discord. The affair lost by my mother-in-law.
Who?
Wife of,
who are you?
I am the wife, Miller. Petition number 6, you are seeing, can you see? Petition number 6 is the wife.
Petitioner number 6 is the wife.
Wife.
Who all are the other?
Others are in-laws members, father-in-law, mother-in-law. My father, my mother, my aunt, my brother.
Oh, your family member.
My family members.
And opposite party number 2 is
Husband.
the mother-in-law.
Father-in-law, others are husband. Lord, you lost me kindly.
What are the allegations? The reverse allegations now.
506. 506 most of.
25, 354, 506.
You lost me kindly see page 41.
Where is your husband?
Yes, madam, I'm saying. Page 41 you lost me.
41.
41.
Yes.
This case has been lost by me. Petition number 6.
Okay.
Against my husband and
This was registered in 2015.
15.
Yeah.
Same day, both the cases.
Hmm.
My case registered against them and my mother-in-law case registered against me. That is page 13. And except
13, 1-3.
yes. 13.
That is dated?
Same date?
15.
5/11/2015.
What is the stage now? 2015 now.
16 law charges. Cognizance order of the year 2016 your lordship. Meantime, 8 years have already elapsed your lordship.
Both the cases lost by me and my.
It's all right, but what is the stage now?
Now after that, you also kindly see page 73.
73.
73.
Okay.
A divorce case has already been filed by my husband.
Yes.
Page 50 is the first page. CP number 89 by 2017. And it has been distributed. Divorce was allowed. Everything is managed.
Yes.
I have filed only for the settlement because it's a arranging.
I issue notice then.
Yes.
Issue notice.
My whole prayer.
Issue notice. There is a divorce now. Right.
Divorce.
Issue notice. Land Counsel, Mr. Maharaja, Land Counsel for the petitioner submits that he seeks indulgence of this court for quashing of the entire proceeding initiated against him initiated against the opposite party number 2. Who is the mother-in-law of petitioner number 6. Petitioner number 6. The petitioner, what happened to the FIR which you have registered?
They apprehend that I may not cooperate them. Because I myself I filed and I ready to quote on it.
Petitioner at the instance of the brief, petition number 6. FIR number Ghatagaon PS case number 194 of 2015 for alleged offences punishable under section 341, 498A, 294, 323, 54, 379, 506, 34. IPC read with section 4 of DP Act has been registered as a counter case, as a cross case. The opposite party number 2 has also filed registered the instant case, a subject case against against her own daughter-in-law and the family members. Mr. Maharaja has taken to the judgment dated 28/10/2022 passed by the family judge Keonjhar in CP case number 89 of 2017. He submits that the husband of petition number 6 had filed for divorce under section 13(1) of Hindu Marriage Act, which has already been allowed, and the marriage between the petitioner number 6 and her husband has been dissolved. In view of the changing circumstances, the petitioner seeks indulgence of this court for quashing of the entire issue notice to the opposite party, written on so and so, and in the meantime proceeding before so and so state. Yes. Further proceeding state. Yes.
Okay.
15.
May I please, Your Lordship? Your Lordship, on behalf of Mr. P.K. Mishra Counsel, can it be taken up at 2 p.m. minutes?
2 p.m. I'll pass it over 2 p.m. only. Yes.
16.
Similar matters, Your Lordship, sir, was pleased to hear that matter, and it was kept for
yes.
It is reserved for judgment. Your Lordship, can be issued if at all matter a departing proceeding one employee has been exonerated.
The same issue, my lords, once somebody is let off in the discipline proceeding as a delinquent, my lords,
Simply awaiting that judgment. Let's leave. After 2 weeks, there's enough.
But in fact, the trial court has insisted upon to frame the charge. If Lordship will pass that adjournment.
If I quash it, even if we charge it from, how does it make?
No, my lord, why not charge?
I did if I quash. If I don't quash, then it's neither here nor there.
Only that arrangement, Your Lordship has passed that adjournment.
Move an application. Simply adjourn. Similar issue. The issue in list in the present case is
the petition has been
pending before this court for determination. Leave the matter from so, and in the meantime, petitioner may move application for adjournment for trial. Yes.
17.
If Your Lordship, in that case, but it has to be listed and again it has to be passed. That is the whole problem.
No, you mention it, I'll do it.
My lord, madam.
If at all.
My lord.
If at all. That's the question. Yes.
Much water flows.
Item 17.
17. Yes. Give me the dates. You give me the date. Forget about it.
26th August 2008 and the NBW 12/12/2022.
22. Huh?
17, 18 same.
1,000 each. 1,000.
18 also same.
18 also same.
Again. Same petitioner, sir.
Same dates?
Same day.
Okay.
Same.
19.
1,000 each.
29 June 2022.
Yes, 19.
22. NBW on 5th October 2022.
24, 500. Yes.
Then 20, my learned friend, adjourn kariya kintu ta dhere bail jaithile 7/7/2022 ଆଉ 24/4/2024 ରେ 205 petition ଟା reject ହେଇଛି.
Simply adjourn court. Yes.
21.
1st November 2023 bail 19 September 2024 NBW.
24, 500.
Then
My lord, bailed on 22/7/2011 and first NBW issued on 16/8/24. 1 day default rate hitch, my lord.
500. Sorry, speak little louder.
NPW issued on 5/2/2024.
Bail?
Hello?
You are on bail or not?
Yes, ma'am.
Give me the dates. Give me the dates.
4/2/2023.
4/2/2023. Yeah? 500 each. Yes.
24. Yes.
Order of NPW dated 1/12/2007, page 35.
Yes. Bail?
Bail, my lord, there are 4 petitioners. Different bail orders I have mentioned in paragraph number 3 at page 3, my lord.
Para 3, page 3. Yeah?
4 applications, 4 bail orders.
2007, 1,000 each you have to pay.
1,000, my lord. To the local bar association.
Local bar. Yes.
25.
Belgium case man. Belgium don 28/26 minute. 28/24.
Bail?
Well, 25/8/2028. Then 20.
Okay. 500.
26.
Tell me.
NBW issued on 25/6/2024.
Yes. Bail?
Bail election करने के लिए bail निकल लेते हैं.
देखो हम 500. Yes.
27.
His Lordship, bailed on 1/5/2010 and NBW was issued on 8/1/2018, Your Lordship.
15.
Your Lordship, 2018.
18. Okay. 10. 1,000.
Obliged, Your Lordship.
1,000 each. Yeah? Each. Make it out.
28.
May I please, Lordship? Bailed on 25/10/17 and NBW issued 5/9/22.
22. Yeah? 1,000. Local bar. Whatever.
Bless
1,000.
29.
On behalf of Ms. Agarwal, may I please the Lordship?
29.
Bail granted on 25/5/2018, NBW issued on 8/5/2023. 8/5/2023, NBW was
8/5/2023 NBW bail
25/5/2018.
18. Okay. 500. Please.
Obliged, Lordship.
31.
Lordship, where
Yes.
My lord, Annex 3, my lord, page 25 and 26, my lord.
Yes.
But here, my lord, I am the opposite party number of OP. In this CRP, execution case number 61/23, my lord. My lord, here conditional LBW issued against me for realization of arrear amount of 48,000, my lord. I am a private tuition teacher, my lord. Your lordship may allow me to deposit this amount in installments, my lord.
You go and tell.
No, I have already gone to the court, not at court below. No, they are saying that you did deposit the total, then I cannot, my lord.
Oh, first, you do one thing. 20,000 rupees you deposit.
10,000, my lord.
No, 20,000 rupees.
No, my lord, 10,000.
See, these are conditional NBW. I can't cancel it.
My lord, I am a private tuition.
Then I'll issue notice and all these things will happen.
No, my lord.
Then, right on. 15,000. The petitioner is agreed by the order dated 2/11/2024, passed by JFC, Jajpur.
No, my lord. That is
Judge Family Court.
Jagat
Judge Family
Singhpur.
Court, Jagat Singhpur. Jagat Singhpur in execution case number 61/2023, whereby conditional LBW against the petitioner has been issued for realization of arrears of amount, maintenance amount payable to the opposite party to the tune of 48,000. 48,000. Petitioner, counsel for the petitioner contends that the petitioner is working as a teacher.
A private tuition.
No, private teacher in school. He
I am teaching the students, but tuitioning, my lord. Not teacher.
Petitioner is running through financial distress and regularly employed, therefore making payment of this huge amount may not be possible in his part. You are teaching tuition and fighting with your wife.
No, my lord, I have already filed section 9. My your lordship, I have already abhorred all these things in my
Petitioner depositing 15,000 rupees.
10,000.
No, 15,000 rupees. The NBW issued by the order dated. Where is that order? Order dated 2/11/2012. The state till 30th of January. Petitioner is granted liberty to move appropriate application before the trial court, seeking make payment of the remaining amount on an installment basis. If such application is moved, same shall be considered on its own.
Pardon, my lord. My lord, 10,000, my lord.
See, I should not have interfered. This maintenance thing, I can't interfere like this. Yes.
Within January 30th.
Withdraw, my lord. My lord, I don't withdraw, my lord. I don't issue withdraw, my lord.
Withdraw.
Yes, my lord. 26.
32 withdraw. 33.
Sorry, my lord. 32. I am counsel for.
Which item you want to withdraw?
26, my lord. I don't 26.
26. What did I do?
Bear the matter. Withdraw.
26 I have already allowed, sir. Why do you want to withdraw? It is cancellation NBW?
Yes, my lord.
That I have allowed. I have allowed. You're not sure about it. I have just allowed just now. We'll see. Allowed. He is not able to understand. Yes. I'll just come.
have already specifically provided, however, bail covers 655 of 22% award was released on
BLAPL number
6655.
6655 of 22.
Bell,
Okay, wait.
my lord, Bell, 6th August 2022, my lord.
20 or 2. Okay. NBW on
3rd September
Ah.
2000.
okay 500 yes
33. 6.24 and date of 6/7/24.
okay 500 yes
34. We entered up 6/3/24 and date of 6/8/18.
18 my lord.
18 okay 500
Problem.
35. NBW for 10/24. Pay all 3/11/14.
500 huh?
Six. NBW on 3/4/25. Paid on 26/5/22.
okay 500
He was deeds on bill on the social 41/8.
sure 500 huh? yes
37.
36 allowed
May I please remember? 37, my lord, the offense under it be to see of the NDPS Act. And the petitioner is in custody. 128 kg of ganja, my lord. And your lordship says directed to call for the CT and CA. CT has come, CA has not come. But in the CT has written that on portal verification there is no antecedent. But I have to take instruction there.
okay seek insert 1 week potluck yes
38.
My lord and brother has solved a copy of deposition just now. The eyewitnesses are there.
But only let's kindly see the age of.
you should have given the earlier
Court would Next week also.
he has to read it huh? next week
Period of detention now age the declare may consider.
that's right I will consider but age is 70
Second mamu hoda
But there are eyewitnesses there.
hoda mamu ko baat dijiye.
30230 the custody from
First from let's say that age.
Custody from 6/5/2023.
what is the stage
Case, my lord, which has been examined.
examine huh?
And the eyewitnesses supported the prosecution.
whatever then okay read it we'll see how many witnesses are there remaining just check it up huh? okay
18টা seconds.
yes next yes
39.
On behalf of Mr. Ponda, my lord, permit to submit, my lord. On behalf of Mr.
Yes.
Ponda. But in this case, my lord, informative UW case, my lord. I was last year also present, my lord. So many adjournments is given, my lord. There are so many adjournments, my lord.
Because the court, my lord has directed to take instruction to the
I also
private advocate who is appearing for the informant, my lord.
I also present today, my lord.
Amount has been transacted with that account. So the direction
I'll just pass over let him
But I
launch for actually the case.
launch for session style for 80 point जाएगी 18 दिन.
let it be day after
day after tomorrow, my lord. Tomorrow.
I am not asking time.
Item 40.
My lord. My lord, item 40, I have just been contacted by the victim side today. I'll file the mention victim side. Notice victim side.
yes
Item 40. My lord. Offense order section. My lord, victim has already been examined.
assume that
I have
PW1
my lord, PW1.
okay
ହେଇଯିବ କଥା ହୁଅ କଣ ଅଛି ତ
what do you say
My lord, the past incident happens 1 year back, my lord. He has not lodged any FIR. After 1 year, she has also not stated about what is the
para 2 just para 2
para 2 man.
yes
My lord, it is the past incident.
you have taken her to Barampur
Yes. I have not taken into Berhampur. I have in the
He was waiting in the bus stop.
Bus stop, I have,
came and
but on this allegation, he has not lost the affair. This is in the 1 year back.
This has happened. Okay.
My lord. Thereafter, my lord, paragraph 3, your lordship, my lord. Another day.
Thereafter, he left me so and so reduced. Para 4.
Para 3, my lord.
Okay.
Came to my house on this affair at best at 511, my lord.
Yes.
My lord, I have just been contacted today, your lordship. I'll file my Ukalaknama today. Anytime, maybe a week, at least time will be given.
Because it appears they were in relationship.
I don't have anything. I just got the lady is waiting downstairs.
Monday. Yes.
Like.
See, he is already there for about a year or so.
My lord, if there is
and
no
it
case,
appears, see, there are 2 incidents. First incident, it appears that there must be relationship. Otherwise, somebody will not sit go to Berhampur.
I will not stand
Like
on the
this.
way. I have not seen anything.
Yes, we'll see. We'll see. Yes.
Oblige, my
May I please, your lordship? My lordship, here in this case, in the last occasion, the last occasion, my lordship granted bail to the other cognizant person having
File affidavit.
My lordship.
Yes.
That my lordship
Put it up. Yes.
Okay.
Yes. Next. 42. Same. 42 also. Affidavit. Yes. 43 also affidavit. 44. Adjourn. Non-APS. Yes. 45.
My lord, the bail matter. My lord, initially the case was registered under section 363, which has taken up investigation by the crime branch, which has subsequently entered in a final report, my lord. My lord, my lord, co-acquit person have been released on bail.
Protest. What are the offences?
My lord,
Yes.
my lord, initially the crime branch has taken
Named FIR. Named FIR. In the FIR, his name was there.
Yes, your
No, name kind. Unknown FIR. My lord, kindly see unnecessary 1, my lord.
Simply say name was there in the FIR or not.
Unknown, my lord.
Unknown.
Kindly see FIR unnecessary 1, page 11, my lord.
And after investigation, final
report. Thereafter, he filed the protest petition informant, my lord. Thereafter, the co-acquit person have been released on bail. All the co-acquit.
You are in custody since?
Custody, my lord. 27/9/2024.
Have you seen it?
No, your
Give it
one more
next week. Next week. Just check it up. Yes. Next week. Protest petition, how much you will keep?
45. Complaints today will notice the proceeding because on the protection.
Acha. Okay. Issue notice to opposite party. 44 na? 45 huh? 45. Notice has to be issued.
I beg pardon, my lord. Item 44, I was just coming from old building.
I'll just put it next week. Yes. 40.
Non-appearance what?
No, non-appearance will not. Key appearance.
44.
Oh, sorry.
45 you notice. You take out notice because it is arising out of a protest petition. Yes.
46.
Notice after 2 weeks.
53, 34, my lord. Already inside the custody.
46, huh?
22/10/2022.
46.
My lord.
Yes.
46 item, you have to obtain the criminal antigen status of the trial. So far, there is 2 petitioners. Wait, I am coming without development.
Order of
there is criminal antecedents of 302 and other 328 and second 307. And the Kamal is also 16 antecedent also.
Then
in this case, out of charged witnesses, already 19 witnesses have already been examined, and the case is waiting for the arguments also.
at this stage, no. You are in custody for both.
22/10/2022. In almost all the cases, he has been acquitted or granted bail, my lord. Yes.
No. 19 witnesses have already been examined.
19 witnesses has been examined.
Then Right on.
So far, the
Petitioner,
rejection comes on 17 witnesses.
Petitioners are in custody since 22/10/2022. Notice was issued to the state state for obtaining instruction. The IIC Hon'Ble PS has given the written instruction with reach again. The petitioner number 1 is involved in how many?
There is two petitions.
I know, tell me 41, 16. Petition number 1 is involved in 8 many and 16 cases, whereas petition number 2 is involved in 18 cases. 18 cases. In the instant case, there are 19 charges already been examined. Matter is that the fake and approved the trial.
21.
Therefore, I'm not going to entertain this petition. Yes, next.
47. Lordship, dispose of the direct complete the trial.
Oh, already it's over.
Lordship, please to reject the bail application.
Yes, yes. Fake and so many cases are there. Once I'll give bail, he'll never go.
No, he has been granted
all right,
bail in
but-
all the cases, and all the cases, some of the cases has been acquitted. Lordship, only
Some of the cases 302 and all.
May I pray one thing, man? Would
Counsel for the petitioner at this stage, at this stage, seeks to withdraw to renew the same before the trial court. This is withdrawn with liberty as spread.
and the trial may be completed within 2 months because the argument stage is also.
You have you read the 15 days back there is a judgment of Supreme Court? Have you read it? Huh? Why are you asking? Very specific judgment. Very, very specific judgment. Says that while rejecting bail application, the High Court should not give, Constitutional Court should not give direction to the trial court for expeditious trial.
But here,
Very, very specific.
But here, what happened? All the witnesses-
Whatever may be, this is the mandate of the Supreme Court. Why should you?
Matter is only posted for argument. That's it.
Whatever. I can't do that. Yes, next. 40?
May I please, my lords?
Yes.
My lord, petitioner with your lordship earlier, in which your lordship directed to, after the deposition of the victim, matter may be renew his prayer. This is second bail application for your lordships.
Custody since?
My lord.
Custody since?
Custody since, my lord. My lord, to 20th December 2023, my lord. And
Yes.
the victim lady, my lord, kindly say, my lord, already supplied the copy in with the PW5, my lord.
Yes.
Now she stated that she is staying, living happily with her family and husband. I think no such allegation might.
The examship is clearly supported the case of the prosecution, and the scissor has been made, nude photograph has been seized from the mobile of the present petitioner.
No, that mobile not belongs to the present petitioner, my lord. My lord, kindly see the deposition of the PW5, my lord. In cross-examination, she has stated that at present I am residing peacefully in my matrimonial house with my husband, and
Who is her husband?
I am not a husband. My lord, what happened, my lord? FIR lost after more than 1 year, my lord. Let me finish. And FIR lost against the present petition after 1 year of the occurrence, my lord. That is during that time I promised to marry. And more than
See
one.
para one, just see the para one. See para one.
Yes, Lord, that time.
Para one, she says that I developed friendship, and we clicked some photograph. They accused and kept physical relationship with me with a promise to marry. Thereafter, I got married with some Himanshu. I am staying happily.
Can you direct me? What is the intention present petitioner?
Forget about it. But now they are happily. Now, yes, right. Petitioner is accused in so and so the case. Engagement with the petitioner, so and so. The prosecutrix has been examined by the prosecution as PW5. who in her examination in chief has stated as under PW 5, para 1 and 2. Para 1 and 2. Relying upon the testimony of the prosecutrix and counsel for the petitioner, the prosecutrix admittedly was in relationship with the petitioner on the pretext of permitting marriage to the petitioner appears to have had physical relations with the child. During the courtship, they had taken certain photographs. The prosecutrix has already married with one Himanshu, and she has stated that she is happy in that marriage. In that view of the matter, she submits that the petitioner is entitled to bail. Petitioner is in custody since 28/12/2023. 2023. How many witnesses are there total?
Five witnesses examined.
There are 21
Out of 21
cases cited by the prosecution. Prosecution will take considerable time. Petitioner is already in custody for about more than 1 year. Hence, I'm inclined to enlarge the petitioner bill if granted bail. Yes. Next.
48. Obligement.
Yes.
Protect with loss. The offense under section 20B2C of NDPS Act, madam. The petition is in custody since 13/1/2024, madam. 13/1/2024, madam.
23.
24, madam.
24, okay.
Yes, madam. And
Yes.
charge sheet on 3/7/2024, madam.
Yes.
He is very much poor, my lord, and nothing became, and the quantity of was 252 kg, my lord. That also seized from the roadside, my lord.
When the ganja is in the road, to everything they transport and vehicle, by seeing the police vehicle in hand, the present petitioner fled away from the spot. At that time, the police patrolling party able to arrest to rescue him and accordingly arrested and identify that these bags are kept on the collection.
Where he was arrested? Nearby or somewhere else? Nearby or somewhere else? What is the distance? Recovery place and arrest place?
Nearby.
This is, my lord, this is the roadside.
You have CD with you?
Yes.
Yes.
During course of production, I was examined and company other witness proved the association of series. That's the main relevant page of Clearly, they took that the right quantity of seed ganja in packets and lost it. And Belgium could not ask, no place.
Next week. Look. Read it and come. Yes. Next.
49.
Yes.
My lord, very last order dated 3/1/25, my lord. My lord, has stated that opposite part number 2 has to come with some amount, my lord. Otherwise, this matter will be cancelled, my lord. Bail will be cancelled.
Okay, that cancellation of bail.
My lord.
Your Lordship, in this case, I am appearing for the OP number 2. Lordship, I am filed IA, Lordship. That is marked as flag A. That is, I am filed IA for the extension of 3 months deposit of cash, Lordship, because financial condition of the OP number 2 is not, his father is suffering from various disease, Lordship.
You made a statement before court and took the bail, and now you are asking for extension of time.
3 months is a long.
Yes, Lordship, last occasion I am also submit before you. That's why I am.
What to do?
3 months is a long time. Bail was granted, my lord. See,
I know, but see, cancellation of bail is not the solution.
My lord.
And these are onerous conditions. The only thing is she herself said that I'll pay. That's the only thing. But the condition is a condition. Either court say or he volunteer to say. And if she goes to the jail, will you get anything?
Reduce to 1 month.
Give 2 months. I give 2 months.
Lordship,
And this-
finally 3 months, Lordship, he will arrange the money, Lordship. No, otherwise, again.
See, you got the bail, madam.
Yes, Lordship, but kindly.
March
3 months,
2024.
at the last chance, but 3 months.
And what have you said in the at the time of hearing? You said
Para 4.
within 15 days from the release, I will pay. That's what you made the statement. I recorded and I gave you bail. And once he filed for cancellation, you are asking for time. Okay, it's all right. I'll extend for 2 months and do it. Okay. Right out. And after 2 months, you renew your cancellation. Cancellation in these kind of cases, you know.
So we paid, my lord.
If she has the money, then only, na? Where from she'll get?
As your lordship.
Right now. The petitioner is the informant, huh? You are the informant. Petitioner is the informant in the present case. Who has filed the instant case seeking recall of the order dated 1/3/2024 passed by this court in APL number 119 of 2024, whereby this court, although admitted the opposite party number 2 on bail, but with the condition that the petitioner shall deposit 1 lakh upfront on the consent that the petitioner shall pay 1 lakh rupees upfront within 15 days from the date of release, and the rest of the amount he would pay within a month. On the basis of the statement made by the petitioner at the bar, the petitioner was admitted to bail by this court. However, after release, the petitioner has not paid a single rupees to the informant. Therefore, the informant has filed the petition seeking recalling of the bail order. The opposite party has now moved an IA number 1 of 2025, seeking an extension of time for making good the payment as has been offered by him while the bail was granted to him. For the reasons stated in the application, the same is allowed. The petitioners, the opposite parties, number 2's undertaking to pay the entire amount with 3 months is allowed. The entire amount you have to pay, not 1 lakh. The entire amount. That's what you have said. Entire amount is
Lordship,
allowed. The 3 months is allowed. However, the petitioner, the opposite party number 2 shall pay 1 lakh rupees within 2 months, and the remaining amount within 1 month. Yeah, within 1 month. Thereafter, as per his own statement made in the application. Hence, this, the entire petition is for the IA as well as the main petition is for the PS.
Renew my prayer after 2 months.
Yes, next.
Yeah.
11 and
56.
yes.
Well, case number is. Well, 11, there are 2 petitioners.
56. 56, what are the offenses?
Well, 56 offenses 341, 323, 324, 307, 506, 294, 34 of the Indian Penal Code. But I demonstrated last occasion the bail order in which it has been stated.
Charge has been 307 is there.
Yes, bail order I have demonstrated last occasion, madam. There was injury.
Simple.
Sustained over the that is a deep injury, and 1 lacerated injury head, which is simple in nature. That the learned
Yes.
expert has observed in the
Yes.
Yes.
Item 11 of the charge sheet filed, I know I the option charge sheet is that is mentioned that.
Which matter you're talking about? 11.
Yes, sir.
Yes. 11 offenses are very minor offenses, 323.
The principal also finds that the increase are simple in nature. That is there. But I know CD also. The invitation disclosed that it is a true case.
These are cross cases. Cross
And
cases.
all the parties are before you.
Okay. Cross. Right. It is item 11 relief. At the instance, who is the Padmacharan Katwa?
See, informant is Lakshmi. Yes. But there are two petitions.
Just see the affidavit which you have filed. So, have you seen it? Who has done it at the top? That parties have settled. He's giving the affidavit, nobody knows. Affidavits are being drafted like this.
But their lordship will see if the petitioners 1 and 2 came to OP number 2 to settle that dispute. And
You read at the top. First of all, read at the top. Joint affidavit by the parties. Who is giving the affidavit? Nothing written.
No.
Straight away. Thereafter, the first paragraph is the parties have compromised there. And who is giving the affidavit? And come to the end. Come to the end. Come to the end. Just see the Padmacharan Khatwa is affidavit and Ye Khatwa. You will not write there who is giving affidavit. I so and so do so hereby solemnly affirm.
In fact, it has been typed in a reverse manner. Your lordship will see the.
And I also do in the reverse manner only now. If you
It's a mistake.
new way of doing it, reverse manner.
In fact, it should have been the other way.
56 affidavit.
Yeah, the affidavit has to be in the form of affidavit. Why should the High Court struggle on this small issue? I don't know.
Item number 56 also same.
Dispute. Filed the joint affidavit dated 7/1/2025 inter alia sitting as under para 1 to 4. The petitioner and the petitioner and opposite party number 2 are present in the court being represented by the respective counsel and identified by them. They've also filed the self-attested copies of their Aadhaar card to establish their identity, which are taken on record. Who is Lakshmi Khatwa? Lakshmi Khatwa.
This should be ordered.
It's separately filed. Yes, separately filed. It's not in the annual. Separately filed. Not the part of that IA. Yes. Which part? Which part?
One Roman 1 mallet order, page 11. Wherein my lords have
10 lakhs.
Yes, my lord,
Yes.
10 lakhs. In fact, I have deposited the same, it is lies with the court. Now I have retired and require money for my medical expenditure. All my extra monies have been seized, my lord. So I am not in a position to meet the medical expenses. So I pray to modify, reduce that amount, my lord.
What he says is this is the bail condition. This bail condition is 2009 and he has been facing the trial. The bail is only for securing his presence. He is 10 lakh rupees he has deposited. He is suffering today. At least 50% will release. Yes. Pass it over. I'll try. See, 50% we can release. Yes.
Security is there, already there.
One, my lord. I am for the opposite party, my lord.
Yes.
My lord. Where, my lord, the matter has already been settled. It has been decided in the matter. So for this petition is concerned, he has challenged the order of maintenance. Maintenance also already been settled. So for some arrear amount is there, it will be settled likely.
What is the arrear amount?
Arrear amount to till that, my lord, there is about 70,000.
You are appearing for?
Petitioner on behalf of Westmont.
You are for?
On petitioner on behalf of.
What do you say? Is there any chance of settlement? It's a matter of 70,000 rupees only.
I'll ask the petitioner.
I'll pass it over. Tell me. I'll dispose it up. How much time you need? How much time you
My
need
lord.
to?
My lord, what happened, my lord? Till that it is 70,000. Court has directed that till the age of attaining the majority. So arrear plus attaining majority, it comes to 175,000.
175.
175. I am ready to pay 1 lakh. My lord.
Seek instruction and come 2 o'clock. Yes. I'll dispose it up. Take it. Yes. That is already taken place.
The I have deposited permanently.
How much?
5 lakhs. In
5
name of the daughter, my lord.
What is the age of the daughter now?
Daughter now, she will attend 18 in the month of November 2026, my lord.
26. But till 26 you have to pay.
Yes, my lord. That comes to 1,75,000.
Just check it up. Huh? Okay.
May for modification of order, your lordship statement come to order dated 18/12/2024, paragraph 4. Your lordship release all the statement except I could not be able to follow up on the 11th day. I have mentioned in paragraph 2 of my IA.
No.
Oh, that is the savings account. That is the money of the mines.
No, no.
That is-
Which part you want modification?
That is your lordship, paragraph 4 of
Yes.
your lordship's order.
Yes.
That is SB account number 33. That is 1, and second is SB account number 3584110010051138. Other accounts have been your lordship released. On the relevant day, they have submitted that has been released in favor. But unfortunately, it has been found that, my lord, somehow or other I could not be able to. The amount which has been seized at the relevant time, that has been withheld. That is the wife's account. That is not the accused account, my lord.
Then you want to re-argue the matter.
No, only to release that certain person, my lord.
Then
Because I have to furnish the security to that extent. Please.
When the application was. Where in the application was.
Yeah.
Flag A of.
Yes, yes, I'm there.
What is it for? SB account.
SB account, that is there.
Now, turn to the last order which is sought to be amended or modified, what that is the paragraph 5 of the last order.
Yes.
Paragraph 5 was contained the instruction Ms. Marana has obtained was with regard to 2 points. One, with regard to the Lord's fixed deposit, that was not.
That has been read.
Okay. That's what we want to know. He is now, he wants to paid with this savings.
Maintaining the balance and the date. That is there. The para 5 I have already checked.
The prayer and this IAM laws.
Huh.
He will allow to operate that particular
That amount which has been seized at the relevant time.
That has to maintain. That's what the para 5 says.
My lord.
That para 5 says he received instruction in so far as the savings accounts are concerned. Those accounts have already been defreezed, maintaining the balance as on the date. So what else you need?
Because the law and code bill or not. But your lordship may kindly dispose of to that extent.
That is what is the observation. With this observation, see, regarding head to the submission made at the bar, I am of the considered view that all the aforementioned fixed deposits shall be released by the lending so and so, furnishing adequate security equivalent to so and so. Also furnishing, the petition shall also move an application of before the court, and we shall allow.
Also maintaining.
Right on. Petitioner is seeking modification of order dated 18/12/2024 passed by this court. To the extent that although the fixed deposits have two fixed deposits. There are two fixed deposits.
Two fixed. I have mentioned in my paragraph 2.
Already been released. However, in so far as the SP account number,
that is, my lord, I have mentioned in paragraph 2 of my IA.
Is concerned. The same
Join the branch.
Not been. He is not able to operate. He is not able to operate. this regard, Mr. Das, Learned Counsel for the Vigilance, has drawn the attention of this court to the para 5 of the order dated 18/12/2024, which reads as under. It is abundantly clear from the observation of this court, as referred to above, that the petitioner is entitled to operate the savings bank account. However, the balance, however, by maintaining the balance as on the date of theft, with this clarification.
Once again, I am submitting. As on date, I have sold my property. That is lying. I will file a security along with the bond.
That is, for that you have to move another 4 feet. You can't.
Because I am the wife. I have no way connected with this.
That is a different story now. That you have, and I have given a liberty to you to move application 447. You move application. Yes.
Urgent.
Yes.
53 my lord, notice already issued to OP number 3 my lord. Nothing is there. Neither ready nor return.
Notice sufficient. Notice
sufficient man. But it is a matrimonial dispute and compromise matter. Paper day after tomorrow for personal appearance. Day after tomorrow, Friday.
Why should I ask you bring?
This one, prefer day after tomorrow.
This is 498A.
498 no.
Oh, bring. Okay, Monday. You bring Monday.
I didn't.
Okay, Friday. Bring them.
Friday.
Friday. Friday will be very difficult, but okay, let. Okay.
54.
My lord, I have instruction for the OP2 for appear in this case, my lord. But unfortunately, Bhinama has not arrived.
Madam, so enters appearance of opposite party number 2 and seek an adjournment to file Vakalatnama and reply to the petition.
My lord, my learned friend has sent only the petition copy. They have
give a copy, yes.
Annex. Petition copy they have filed. They have not filed the, they have not given the annex.
He has not received the copy. Entry mode to continue. Yes.
55.
Lordship, item 55, I seek for adjournment because as per the notice has come, the opposite party has refused to receive the letter. He has done this by mistakenly.
Service.
He has done this by mistakenly. For my instruction I have received, he is going to appear. So I seek for adjournment so
Okay.
that he is going to.
The notice was the opposite party number 2 has refused to accept the notice. However, the counsel for the petitioner submits that you got the instruction.
Yes.
You got the information that the opposite party number 2 would be appearing through counsel. Leaves the matter after. Please.
57.
57 may last occasion my lordship was directed for to file the consolidated petition. I have filed the consolidated amendment petition for modification of order dated 19/12/2024. My lordship. That is in IN number 8 of 2024-25.
Yes.
I have my mistake was my GR number was incorrect, my lordship, and
Which part you want to correction?
I have filed the IN number 8 of 2025.
IA number 8 of
25.
Right. For the reasons stated in the application, the same is allowed, and the petitioner is allowed to amend the petition insofar as GR case number.
GR case number correctly as 9 of 2024, pending in the file of Lord and Additional Session Judge, Special Judge, Pukso, Kendrapada.
Accordingly, the order dated 19/12/2024 is also to be corrected. Correction. PS case 93. Allowed.
Shall I pray one prayer? And the offense is that is turned to 363 mentioned in my lordship order page 3. Khali 363, 376, 2N, 109, 34 of IPC and read of 6. Sorry. That is material mercy.
But in the FIR, it was 363 only.
FIR.
And that's what I have written.
That is correct. Then it's not okay.
I have not said that.
Normal, sir.
Only page number 3.
Only extending some period of interim
For the
interim order.
for the petition
Surrender
submits that for the maybe the petitioner is seeking extension of time for surrendering or of surrendering of appearing before the court for the reasons stated above. Accordingly, the time is extended up till 30th of January.
Obliged.
Yes.
58.
Yes, 58.
Here, my lord, I'm praying for quashing of FIR, my lord. The alleged offences are under section 336 of IPC and 185 of the MB Act, my lord, drunken drive case, my lord. And here I have filed an IA for dispensing of the certified copy of the FIR.
It's all right, allowed. You tell me.
My lord, the FIR was instituted by one SI of traffic police on 7/4/2024. It is alleged that the petitioner was driving his car in a state having 260 mg per 100 ml of alcohol content. Fact is that the petitioner was a passenger. The driver was driving the
investigation
car.
is going on.
My lord, in FIR date is 7/4/2024. My lord, till date no charge sheet has been
Oh, it's all right.
the petitioner is a private working in a TCS company. My lord. Tendency of this application.
What can I do? You are driving.
No, my lord, that is the allegation, my lord.
That will be verified by them.
My lord, till that no charge sheet, nothing has been submitted.
I'll just simply you withdraw it, and I'm asking them to file, investigate and file the charge.
My lord, lordship may keep it some of-
April 24, the FIR.
Yes, my lord. April 2024.
Right now, petitioner is by invoking the inherent jurisdiction of this court under 482 CrPC. Petitioner is seeking passing up of the FIR. Chandrasekharpur case number 305 of 2024. And counsel for the petitioner submits that the case is absolutely baseless, and he has been falsely implicated in the present case. He further submits that although the FIR was registered on 7/4/2024, but charge sheet has not yet been filed. But for the pendency of the investigation, he has been facing a lot of difficulty in this working front. Hence, he seeks indulgence of this court. Since Mr. Vishal and counsel for the state submits that the investigation in the present case is still going on. At this stage, I'm not inclined to entertain this petition, but it is expected that the investigating agency shall conclude the investigation as expeditiously as possible. Yes, this goes up. Next.
59.
In my lord, I am for the petition. And that events, my lord, the second appeal has been dismissed. The concurrent findings. And thereafter, my lord, a friend has filed a review application. The lordship knows that the specific, what is the, that is order 47, rule 1 read with 114.
Yes. What are the grounds, sir?
Pardon?
What are
I am for the petition.
Yes.
On behalf of the Prabhu Chandra Das, he is not out of station. Kindly take
My lord, your lordship, he has availed for a moment. The
Yes.
lordship turn to order dated 6/5/14.
6/5/14
in second appeal. That is 184 of 12.
Yes.
This honorable court directed the present review petitioner to submit the accounts. He has not submitted the account. And now review has been filed, avail the stay, sign and signature of the final decree has been installed. In one hand, he has violated the order of this honorable court. In other hand, avail the
apparent error you show me.
Yes.
Why review should be entertained? Concurrent finding of both the courts.
Miller, the conducting advocate is out of station, Miller. So kindly take that.
And the Honorable Court has taken note of all the facts and the evidence also. Section 14 of the Limitation Act has been vividly described, relying upon the judgment of the Honorable Supreme Court. The expansion of otherwise also described there. That apart, your lordship, that on proviso of 100, section 100 of CPC, that has also been answered.
Yes.
Now on the same plea, a review has been filed on the guise that the question of limitation has not been dealt.
Drawing of the decree is stayed by this court in the review petition.
Kindly take up after 2 weeks, Miller.
See,
And I am suffering
in
because of
22, September 22, the drawing of decree has been stayed by this court
Miller.
in this review petition. You can't take advantage of that. Next week, Rokovi.
Next week.
They by way of last month. Yes. Yes.
Item 60. Item 60. What is the sufficient?
Sufficient. Are you appearing for?
61.
So it's in good. No, non-APS for despite service. Huh? Service is complete. Service is complete despite service on opposite party. Number one, na? Number one, non-identified appearance. Huh? Jahrullah. None is appearing for today. And Mr. Jahrullah will call for the petitioners. Please the matter. Yes.
61.
Yes.
May I pray, my lord? Here, my lord, I have prayed for quashing of the affair. The petitioner is the principal of Jawahar Navodaya Vidyalaya, and the complainant is the assistant teacher there. The entire allegation in the affair is that I've taken some action in official capacity, which triggered an inquiry against her, then a transfer, then I have filed a caveat applications, there have been deduction, excess deduction of TDS, and all this quaternion allotment delay. Hence, the allegations are all in the 3 SC/ST Act.
Yes.
And your lordship may kindly go through, I'm drawing your lordship's attention to the affair itself. The complaint runs into 4 pages, and your lordship find out not a single ingredient is satisfied, that whether I, knowing that she is a person belonging to the scheduled caste category.
It is arising out of a complaint case.
No, my lord.
Where is the FIR? Charge sheet, nothing is there.
Charge sheet has not been filed. Probably there is no reason for why they are delaying in filing the charge sheet.
Where is the FIR?
Where is at page 16?
Charge sheet has not yet been filed.
Though it's an old case, and charge sheet
20. Yes. Who is appearing?
Charge sheet, had they filed charge sheet, everything would have been sorted out.
Yes.
There is no prosecutable evidence.
You don't want to file charge sheet.
And there is direction of this honorable court to file charge sheet.
Why are you not filing charge sheet if you want to file?
Yes, my lord.
Otherwise, file closure report if nothing is there. See, 2020, what are you doing? By way of last opportunity, yeah? And it's made clear that no further adjournment shall be granted on this matter. You can't do that. Otherwise, I'll quash it, I'll tell you, if you are so casual about it.
Interim order to continue.
Interim order.
Subsequent allegation against the petitioners, my lord, there was a festival in the year 2016, my lord. After completion of the festival, my lord, the 2 groups were started their procession, my lord. Due to hot conversation, there was a
Where is the charge sheet?
Charge sheet, my lord, filed on.
Where is the charge sheet?
Charge sheet, my lord, filed on 26/7/2000.
Where is that?
Charge sheet not filed. Charge sheet not filed, my lord.
My lord, show me that. What are the allegations in charge sheet?
My lord, my humble prayer is, my lord, the SCST Act is not made out to this, my lord.
Unless I see the charge sheet, how will I make
My
out?
lord, I have annexed, my lord, 161 of the informant and also the eyewitness who are the police, my lord.
Counsel for the petitioner seeks to file the additional document to substantiate it. Let him do so within a week. Please the matter of 2 weeks.
My lord, make I'll have a glance only page number 39, my lord.
Charge sheet has already been filed. I need to see the charge sheet. Unless I see the charge sheet, how can I quash?
My
Show me the charge sheet. What are the material? What are the allegation and all? Then only I can do that. Yes.
There is an IM, my lord. There is an IM.
File the charge sheet. Incomplete petition. Here. Next.
Item 15.
Lordship, may I please the court? Your Lordship, I'll be making my submissions on behalf of learned counsel, Mr. P.K. Mishra, my lords.
Yes.
Your Lordship, the order which we seek to challenge is at page, Your Lordship, Annexure 10.
Annexure 10.
Page 55, my lords.
Okay.
Your Lordship, briefly, the facts of the case would be that we are purchaser of a JCB vehicle, my lords. Now, the JCB vehicle, my lords, was actually seized by the police.
Three of you have purchased.
My lords, only one. I am the purchaser, my lords.
Okay.
Now, my lord, when I had purchased, I had executed an agreement with the daughter-in-law of the owner of the vehicle that she will take care of the vehicle and will pay me rent of 50,000 rupees per month. So she did not pay me that rent with respect to that particular excavator vehicle of JCB, my lords. What happened? I filed an FIR, my lords. A GR case was registered. In that FIR, they filed a 457 application because the vehicle was seized in that particular GR case, my lords, by the IO. Now, when the vehicle was seized, my lords, their 457 application was rejected, my lords. They came in revision, that was also rejected. Now, your lordship, 557 application in that particular GR case for the release of vehicle in my favor, that was allowed. And subsequently, a revision was filed in which it was directed that that vehicle may be delivered to me. So there was a specific order to that effect. Now, my lord, subsequent to this, the opposite party number 2 filed a 1cc case. Got one particular GR case registered, got the FIR registered, my lords. And in that GR case, they preferred a 457 application, my lords. Again, now that 457 application was rejected. But what we do not understand was that during the pendency of that application, the IO moved an application for release of vehicle in favor of the opposite party number 2. So on the same day, on 2 GR case, there are 2 orders contradicting each other and virtually recalling the order.
It was not informed to the court.
No, my lord.
There is an order.
No, not informed. We were also not served a notice of that particular application filed by the
issue notice. Issue notice to opposite party.
I will not see Annexure 9 and Annexure 10.
Opposite party number 2 written also. In the meantime, the operation of which order?
Your lordship, Annexure 10, my lords.
2/1/25 crores.
2/1/2025.
Operation of order dated 2/1/2025. LCGM Kamakhya Nagar in GR case number 9696 of 2022.
Your lordship, I have an interim application. Your lordship will see Annexure 10. The court had ordered.
I have stayed the operation.
My lords.
I stayed the operation.
But my lords, he has delivered the possession of the vehicle.
Now what can I do? I can't do.
So lordship may just direct that nature and character, third party rights may not be.
No.
They'll sell it to someone else, my lords.
No. I stayed with this. Yes.
Much obliged.
Include the I.
Lordship, an urgent certified copy of it.
It is already released. What to do?
Well, the problem is it has been released in favor of the OP number 2, but the court had ordered.
I can't pass an ex parte injunction kind of order.
The court had ordered the IO to seize it. He has taken it and given it to them.
I don't know. We should notice. Let them come. Yes.
Item 50.
Yes. 50.
So in that case, my lords, I have to take instruction on that matter. It's not there, my lords. I have also instructed to make submission for lordship. This matter taken up day after tomorrow. Mr. Maharan has got the instruction.
Next week. None. Simply.
I have also intimated that lordship was inclined to release 50% of that security amounts. Take instruction.
Next week. Yes. Next week. Yes.
51.
Simply urgent. Non-NDPS.
For one of the matters virtually argued at length by both me and my learned friend for the informant and also the statement. Last occasion, it after hearing my learned friend for the informant, your lordship had asked me to explain about that.
Show me that SMS and
Yes, WhatsApp message and the lecture. Now, I examined it and I'm reinforced in my submission that this is all does not make out absolutely no. The letter, there are three things, Manoj. Three submissions I have to make today. First of all, that letter, so-called letter is only 7 words. It is not I need too much. Now, there is no signature there.
yes. Handwriting, have you checked up?
It has been sent to the handwriting expert. Handwriting expert also has given the report, Millard. In the if your lordship will see the cognizance order, Millard. In the cognizance order, Millard, it has been reasoned by the London magistrate that the report has been called for from the say, Millard. Your lordship, for a moment, Millard, I am drawing your lordship's attention because here it has been annexed with, but here with as annexure 1. Millard, your lordship, kindly see that handed to CIDCB VSR envelope, Millard. That is there, Millard. Handwriting expert's opinion is there. The police has called for, Millard. Millard, only the trial court can say, Millard, that envelope is in the seal cover, Millard. After perusal of the all those things, Millard, the cognizance has been.
Second, Manoj, I've also gone through the entire all the WhatsApp messages, Manoj. I am what Manoj is very interesting is that if an incident is supposed to have committed on the informant 2.5 years ago, for 2.5 years she continues to chat on the WhatsApp with the informant, Manoj, and the natural response would be to block.
That I will answer, Millard.
Block the.
They were in relationship.
Manoj?
They were in relationship. It looks like.
I'm not indicating anything. I'm only saying that this is not a normal natural behavior, one. And the factor also in fact remains that she has never disclosed. To the SP, nobody.
It could be a case of consent.
It could be anything, Manoj. And second one, all these evidence of under 65, Manoj, under WhatsApp Manoj messages, directly Manoj, this is hit by the test Supreme Court in this judgment Manoj 2020 volume 7 SCC Manoj. I'll just place one paragraph. What is the Manoj requisite for any evidence under section 65B4 electronic evidence Manoj to pass muster, page 29. Your Lordship,
Mr. Vishal, please sit down.
Yes.
Yes.
These are the 5 criteria, preconditions, the mandatory preconditions. Page 29.
Where are you?
I'm in page 29, paragraph 26.
29.
Page 29 of that, and paragraph 26.
Not paginated.
Again?
It is not paginated.
No, judgment.
Which judgment?
2020 judgment.
Okay. 29. Page 29, huh?
Statement.
Okay. Yes.
Chote italics से paragraph 15 लिखा है.
Yes.
Under section 65D4 of the Evidence Act, if it is desired to give a statement in any proceedings pertaining to an electronic record, it is permissible, provided the following conditions: the certificate which identifies the electronic record contained in the certificate statement. The certificate must describe the manner in which the electronic record was produced. C. The certificate must furnish the particulars of the device involved in the production of that record. None of the mobile phones have been seized. No certificate by the anybody.
That those things can I do in cognizance?
No, this is mandatory. Not in cognizance. I'm just on the I was conscious that your Lordship will come to this question, will fall for me, Lordship.
Whether particular set of evidence is admissible or not,
But on the face.
all these things in the cognizance stage.
But
how
on
can
the,
you-
on the face of it, on the face of it, man, on the face of it, yeah, this is not just my other arguments relating to.
Oh, that's
my-
there, that's there,
on that. And here also, even the WhatsApp messages also, there is nothing that,
Issue page it kar
Right.
and file it and I'll put it for
I will-
hearing.
I will.
Because today it may not, it will take little time. Come with judgment, huh?
My lord, I have
Just list it after 2 weeks or so.
the written submission, my lord, I have prepared, my lord, but I will file a letter, my lord.
You exchange it, huh? You also exchange.
My
so
lord,
that, I'll come.
if I will get, my lord,
No, no, yes, I'll hear it after a week or so.
I thought you close it.
No, I'll hear it. It needs hearing. Yes.
Lakshmi giving us a date. No?
He'll give a date. Adjust, he will adjust the, date of hearing and give it. Interim or to continue. Yes.
Please, Your Lordship. On behalf of Mr. A.K. I kindly pass over, madam.
Pass over, adjourn.
Adjourn.
Yes. Today no work.
63
Yes, sir. No, adjourn. Today it's a heavy board.
years are already passed the stay order.
He will give a short date. Yes. Yes.
64, your lordships.
Yes.
64, your lordships, is a CBI matter. Before starting the matter, your lordships, I would like to congratulate Mr. Tanveer Ahmed Mir for being designated as a senior advocate from Delhi High Court.
I'm grateful to my younger brother, my lord.
Now, lordships were challenging. Sorry.
Everybody joins to congratulate Tanveer.
Yes, my lord. I'm so grateful, my lord.
Yes.
I express my heartfelt gratitude, my lord.
Yes.
Now, lordships may kindly come to page 58 to 62, where we are challenging the order dated 27.
What are you seeking in this petition?
Your lordships, this is at the stage of the investigation. We are only seeking, your lordships, the voice sample of the accused will be taken so that it can be compared with the phone tapping which was done.
Okay.
This is not the stage of the trial, your lordships. We just want him to give the voice sample so that it can be compared.
Now, where is the impugn order? Have you applied
Yes,
in the trial court? Where is
Under
it?
Annex
5.
Show me.
Your lordships, start. You want to read the
Annexure 5?
Yes, your lordships. Annexure 5. 58 to 62 page.
Yes. Yes.
Also, the operating part of the order, your lordships.
67.
Is that page
67.
67, okay.
This is page 67. He's saying that in the circumstances and in absence of any valid foundation, the respect of interception and recording of the conversation stated be made with accused person. This court is of the opinion that the case does not come within the purview of the exceptional circumstances. But so nowhere in CRPC or any of the Supreme Court judgment it says that voice sample can only be given in exceptional cases. Voice sample, your lordships, is necessary for investigation. Here the stage, your lordships, is not of the trial or framing of the charges. After voice sample, if it is compared, then it can be known that, your lordship, whether the voice belongs to him or not. At this stage, your lordship, there is no point in objecting it. Now, the only limited question, your lordships, is that whether the accused or the defense can ask for or to produce some documents at the stage of investigation, your lordships. He is saying that, your lordships will read page 66. The learned court, your lordships, is saying that there is no material available whether those orders issued by the Ministry of Home Affairs from time to time were placed before the review committee or not. That the trial the review committee or not is a matter of trial, your lordships.
Right.
These are the now, lordships, the first judgment I have cited, your lordships, is a judgment of the Honorable Supreme Court Ritesh Sinha versus State of Uttar Pradesh, which was followed by the Honorable Supreme Court, your lordships. in Praveen Singh Chauhan versus State of Gujarat.
Yeah.
This Ritesh Sanna judgment, your lordship says that. I'm reading the Placidum, your lordships. A judicial order compelling a person to give a voice sample violate the fundamental rights to privacy article. It is the question.
Where are you reading? Where are you reading? Para?
Lord, starts with para 5.
Yes.
There were two questions, your lordships.
The principal question arose for
Yes,
determining.
the principal question arose for determination of the appeal, which has been set out in order of Ranjana Prakash Desai in the following terms: whether Article 23 of the Constitution of India, which protects a person from being compelled to be witness against himself, extend to protecting such accused from being compelled to give his own
Right
voice
to
sample.
silence. Okay. Next.
The court is saying that it is not. The court is saying that it is not violative of Article 20, Clause 3. Number 2, the court is saying that when there is no express provision available under the statute, the court can exercise powers under Article 42 and direct the magistrate to give voice samples. Now, your lordships may kindly come to paragraph 27, which is the operating part of the judgment, last para.
Yeah.
In the light of the above discussion, we unhesitatingly take the view that until explicit provisions are endrafted by the parliament, a judicial magistrate must be considered the power to order a person to give sample of his voice for the purpose of investigation of the crime.
Yes.
That means the magistrate has the power to decide that the accused can give the voice samples. Here, the learned magistrate is saying that it can be done only in exceptional cases, your lordships.
Yes.
I don't know how he could involve that jurisprudence that it can only be done in exceptional cases. Now, your lordships, I have given a small index, your lordships, in which, your lordship, the certificate which is required under 65B of the Indian Evidence Act.
Para 26 also you, Mr. Rai.
Yes, your lordship.
Read para 26.
Would a judicial order compelling a person to give a voice sample to violate the fundamental right to privacy is the next question. The issue is interesting and debatable, but having been argued before us, it will suffice to note that the view of the opinion rendered in modern details such as such fundamental right to privacy cannot be constituted as an absolute. Must bow down to compelling public interest. We refrain from any further discussion and consider it appropriate not to record any further.
The first question frame in para 5 has not been answered.
Yes, your lordship. But here the topic is not that whether it is violative of Article 23 or not. Here the topic is that, your lordships, whether the magistrate
I am sure that he would be emphasizing on that.
Yeah. Yes. Now, your lordships, his only limited ground which was taken before the Honorable Trial Court was that those minutes of meeting, your lordships, were not placed before the review committee. Now, your lordships, might kindly come to Section 114E of the Indian Evidence Act for a moment.
Evidence.
There. 143.
Yes.
Since 114E Indian Evidence Act says that the court may presume existence of certain facts which it thinks is likely to have happened.
Yes.
Regard made in the common course of the natural events, human private business in relation to the facts of the particular case. E says that judicial and official acts have been performed regularly.
Yes.
So it will be the presumption of the court will presume that the judicial and the official acts have been done regularly by the police officers. If they are disputing it, your lordships, the burden of proof lies on them, and that burden can only be discharged, your lordships, at the stage of the trial by laying evidence by the defense, not at the stage of investigation. This is not even the stage of framing of the charges, your lordships.
Right.
Secondly, your lordships, The test of admissibility of the evidence, your lordship, lies in its relevancy, your lordships. Unless there is any express or necessarily implied provision, your lordships, it has to be only seen that whether the evidence is relevant or not, your lordships. Now, your lordships have given documents of the certificate which is required under 65B of the Indian Evidence Act, your lordship, 65B4C. This is Exhibit D19, your lordships. Therefore, the certificate which is required under the Indian Evidence Act, your lordships, that has been provided, your lordships. PW4, your lordships, is the statement of the
where is that certificate?
Certificate, your lordships have given a small index I have made. My junior has.
Your lordship,
I've just passed it on, your lordship.
It is at the my lord certificate is at page 30.
Page 13 of the
this
compilation.
compilation, my lord.
Okay.
It is my lord's P19 along with the charge sheet so filed.
One PW4 statement, your lordships, I have annexed. He is the system administrator, your lordships. On being stated that I have my position as a system administrator is not to actually determine the call contents or relevance of the calls as limited to provide. Your lordships, he was there, your lordships.
Tista Haldar.
Yes, your lordships.
The certification.
Sibo Sankar, your lordship. Sibo Sankar.
No, whether this certificate is in conformity to 66 or 65B.
Yes, your lordships. Yes, your lordship. D19. Deputy Superintendent of Police, your lordships. Telephone section, your lordships. Tista Haldar. Absolutely in conformity, your lordships. D19 is the exhibit, your lordships.
Yes.
Now, your lordships, annexure 3 series, if your lordships will see.
Series of your petition.
Yes. Para 31 to 52, page 31 to 52.
Yes.
It is the order of the Home Ministry, your lordships.
Yes.
Which is in conformity with your lordships rule 3, 4 and 2D of the information technology. The Union Home Secretary is satisfied that it is necessary to monitor this telephone as the information cannot be acquired through any other reasonable means. So, your lordship, due procedure was followed, law was followed, their phone was intercepted. Now, only limited period, your lordships, that they should give their voice sample, which will be only compared. Now, he is not an accused, your lordships. Suppose after the comparison, it is found that both the voice matches. At that point of time, your lordships, we can say that this is violation of Article 20, Clause 3. Now, if we are asking for the voice sample, it can't be presumed that he is already an accused, your lordships. The voice sample is necessary in order to compare. After comparison, it can be known that whether he has done something or not, your lordships. Now, your lordship, he is asking.
Now they are not made accused so far.
Now they are accused, your lordships.
You say that they are not accused?
I am not saying that, your lordships, for the purpose of evidence.
Okay.
Now, your lordships, they are asking for the production of a document. Under which provision of law they are asking, your lordships?
Yes.
They are asking something to be produced under 172(3) of the CrPC. Accused or his agents doesn't have any right to see the case diary when the investigation is pending. Now, they are showing that you please give us some documents which is in relation to whether the minutes of the meetings were placed before the review committee or not. Under which provision of law?
Where they have asked? Let us see.
They have asked, your lordships.
Where is that?
That is in the submission, your lordships.
Have they moved any application or anything?
No, your lordships.
Where have they asked?
They have not moved any application, your lordships, but that was the submission which was recorded by the court. The order of the court.
Show me that part of the observation.
Page 62, your lordships.
62, okay.
Yes. Now the argument has been advanced by them that in the meantime, the prosecution has obtained the order by the Ministry of Home Affairs and the copy of the same are filed along with the case diary, but there was no submission advanced whether the said orders were accepted by the review committee or not. In the absence of the same, the order issued by the Ministry of Home Affairs, Government of India is non-est or inoperative. Thereby, the interception of the mobile phones of the accused person is per se illegal from its inception and the same cannot be utilized for any purpose. In the support of such contention, a decision of the Honorable High Court in Jatinder Pal Singh versus CBI was relied upon.
Yes.
Now, your lordship, Jatinder Pal Singh versus CBI, I have read that judgment. That judgment, your lordships, was at the stage of the framing of the charges, not at the stage of the investigation, your lordships.
Yes.
In future, your lordships, if they feel that something has been done which is not in compliance with the law, they have remedy available under the law. But now at this stage of investigation, lordship, they cannot raise a question which is to be determined at the stage.
Yes.
Now, lordships, production of the document demanded by the defense, your lordships, can be done only by invoking your lordship section 91 of the CrPC.
Yes.
Now, lordship, there is a recent judgment of the Honorable Supreme Court, State of Rajasthan versus Swaran Singh Baba. Lordship may have the judgment. Relying Devendra Nath Padi, your lordships, the court is saying that paragraph 6, your lordships.
6.
Any document or other thing envisaged under the aforesaid provision can be ordered to be produced on finding that is same necessary desirable for any purpose of investigation, inquiry, trial, or other proceeding under the code. The last few paragraphs, your lordships, insofar as the accused is concerned, his entitlement to seek order under 91 would ordinarily not come till the stage of the defense. When the section talks of the document being necessary and desirable, it is implicit that the necessity and desirability is to be examined considering the stage when such prayer for summoning of the production is made at the party who seeks it, whether police or used. Now, your lordships, as far as the demand of this document is concerned, your lordships, about the review committee meeting, that cannot be sought for, your lordships, at this stage, with due respect, your lordships.
No, but they say that it is unless ratified by the review committee, you can't rely upon that. That's what they're key. They're not asking for the copy.
No, your lordships, as far as that document is concerned,
whether these
that will be decided by the trial court at the
place before this home affairs department's circular was placed before the review committee.
Your lordship, whether it was placed or not, this is not the stage to be. This is not to be stage to be decided. Now, your lordship,
but they're not asking the copy of it.
Now, your lordship, for a moment,
In the absence of it is ratified by the review committee, whether it is inoperative or not.
No, it is not inoperative. If it is inoperative, they have a remedy available. They can seek for.
So don't take me to 91. They're not invoking 91 at this stage.
Now, your lordship, may kindly come to another judgment. Accepting without admitting for the sake of arguments, my first submission.
But 91 is they have not sought any document.
Your lordship, my first submission is that these are available.
Yes.
Available in terms of the presumption which is under 100.
Kindly see the observation of the trial court. The trial court only says that it was not placed before the review committee, so therefore it is nonetheless or not inoperative.
Trial court has accepted the submissions and trial court has accepted a judgment of Mr. Jatinder Pal Singh of the Delhi High Court. That judgment is also not applicable, your lordships. I'll read that judgment. I have a copy of that judgment.
Yes.
Your lordship, may kindly for a moment, your lordships, have that judgment. Jatinder Pal.
Yes.
Trial court has given the observation on the basis of the submissions made by Mr. Mir on the basis of your lordships.
Yes.
What this judgment, your lordship, says? The submissions of Mr. Sudhir Nandrajog, your lordships. He has made two submissions. The senior advocate is submitting, your lordships. Paragraph 6B. The senior advocate submitted that the manner in which the alleged telephonic conversation was intercepted and recorded by the concerned authorities prima facie illegal, and no reliance can be placed on them because of the fact that they were obtained illegally. Then he gave a judgment. Now, your lordships, he also argued compact disc of the alleged intercepted phone calls were recorded was neither sent to CFSL nor was used as a relied upon evidence. That means there was a requirement to send it to the CFSL. Therefore, he has argued that, your lordships. If there was no requirement, he would not have argued that it was not sent to the CFSL. There was a requirement to send it to the CFSL, but in this case, it was not sent. He further argued that the compact disc was neither sent to the CFSL nor was it used as a relied upon evidence. Thus, it was argued that same would not have been admissible under 65B. Now, here certificate under 65B has been taken. We are relying it as a evidence and we want to send it to your lordships as per their submissions. As per the judgment relied by them, there was a requirement and we also want to fulfill that requirement, your lordships. Now, your lordships, if your lordships will come to now, if your lordships will come to the conclusion. If your lordships will come in paragraph 81.
Yes.
Paragraph 81, point number 4, your lordships.
Yes, please
Tape
read.
records of calls intercepted in the instant case are not admissible since due procedure of the interception under the telegraph wire has not been followed. Further, if same has not been verified by the FSL report, your lordships.
Yes.
That means it needs to be sent to the FSL. After that, when it comes at the stage of the framing of the charges, then arguments can be taken. The judgment of the court says that there is a requirement of sending it to the FSL report. And the submission made is also that it is required to be sent to the FSL. After the FSL report comes, your lordship, then these arguments can be taken at the stage of the framing of the charges. Now, for a moment, your lordships, accepting without admitting for the sake of arguments, these were taken illegally, your lordships. For a moment. Now, lordships have time and again heard of this proverb that the procedures are handmaids of justice. The primary objective of the procedure, your lordships, is to facilitate the law, not to strangulate it. The judgment of R.K. Malkhani, your lordships, 1973, volume 1, SEC, page 471. Paragraph 23 or 24, your lordships. R.K. Malkhani, which was not discussed by the Delhi High Court, your lordships, in Jatinder Pal case. Tape recorded conversation is admissible provided first the conversation is relevant to the matters. Secondly, there is identification of the voice. And thirdly, the accuracy of the tape recorded is proved by eliminating the possibility of erasing the tape record.
Which paragraph you are reading?
Paragraph 23, your lordships.
Yes.
A contemporaneous tape record is the relevant conversation is relevant fact is admissible under Section 8 of the Indian Evidence Act. It is res gesta. It is also comparable to the photographer. The tape recorded conversation is therefore a relevant fact and is admissible under Section 7 of the Indian Evidence Act. Now, your lordships, paragraph 24.
Yes.
It is very, very crucial. The judicial committee in Kuruma, son of Kanju versus R, dealt with the conviction of the accused of being in unlawful possession of the ammunition which has been discovered in consequence of a search of a person by police officer below the rank who was not permitted to make such searches. The judicial committee held that the evidence was rightly admitted. The reason given was that if evidence was admissible, it matters not how it was obtained. That means, your lordships, if evidence has been obtained illegally also, its relevancy has to be seen.
So admissibility is not the question. If they'll give the voice sample, that will be admissible. That's a different story altogether. Admissibility is not the question. Question is whether you can compel them to give voice sample or not. That's the question.
Of course, your lordships.
That's the question. You address on that.
2 judgments have been given, your lordships.
Yes.
There is no question of compelling.
Those judgments are relevant.
State of Rajasthan versus Swaran Singh and Ritesh Sinha. Those judgments are directly applicable, your lordships.
Yes. Yes.
Yes. I'm so grateful to my learned friend, Mr. Milords, for his erudite submission. I would just beg to Milords make one correction.
Sir, can you use the mic? Mic.
In the mic is off. In the factual narrative, Milords, that my learned friend Milords humbly submitted before this honorable court. Now, Milords, this matter at this stage, Milord, or at the stage when this petition has been filed is not at the stage of investigation. 2 dates are very crucial, Milords, rather 3 dates. The FIR, Milords, is lodged on 3rd of August 22. Milords, the charge sheet under 173 subclause 2 is filed on 2nd of October 22.
Yes.
Cognizance, Milord, follows. This petition, Milords, to assail these 2 orders merged with each other. This is not one order. These are 2 orders. This is filed on 11th of October 22.
Yes.
Now, your lordships may kindly see, Milord, the first order which my learned friend, my lords, placed on record, which also makes a mention in the second order that he has challenged. The first order of dismissal, my lord, was on 10th of August. So, my lords, when my learned friend, my lords, filed these applications to seek the, please have, my lords, page 20. So, two orders, my lords, have merged together, my lords.
Yes.
Because by both these orders, twice the application of my learned friend's client stand dismissed by the learned trial court. First order is 10th of August 22 at page, my lords, 21.
Yes.
My lords, going on to page, my lords, almost 30.
Yes.
At the time when he filed these applications, obviously, my lords, the investigating officer case presents a case diary.
Right.
In that case diary, he did not even have the permissions. At that time, there was no material in support of, my lords, the application. So, my lords, the learned trial judge called upon the investigating officer to show the case diary, noting that he did not have no documents at all.
Yes.
The investigating officer, my lord, subsequently renews this application on a second count and says that please give me a chance once again. Then, my lords, this detailed order is passed.
Let us see the operating part of this earlier order.
Yes, please may kindly have one.
Yes.
The order, my lord, starts at page 20 and insofar as, my lord,
27.
yes, my lord. Please see, my lords, lordships may first see, my lord, I'm so sorry. May kindly see, my lord, page 22.
22.
My lords, the last paragraph at page 22.
Yes.
Learned counsels for respective accused persons objected to the petitions filed by prosecution to take, my lords, the police remand and collect voice samples of the accused persons. It was contended that recording of conversations through interception was not in accordance with provisions of Indian Telegraph Act. It was contended that neither in the FIR nor in any forwarding report, recording of conversation of the accused persons amongst themselves through interception was reflected. From the petition filed by the IO to take accused persons on remand, it appears that IO specifically stated during investigation that accused persons did not fully cooperate. So far as collection of voice samples of the accused person is concerned, in today's petition, IO has divulged about recording of conversation of accused persons amongst themselves. Therefore, only with an intention to harass has filed that application not only to take but also to create evidence by collecting. During the course of argument contended that prior lodging of FIR drawl conversation was recorded by interception. The learned PP contended that prior the conversation order was obtained. Perusal of materials available on record and case diary produced by the IO, this court does not find any valid or convincing document materials about recording of the conversation of the accused through legal process. And, my lords, therefore, this application may see, my lords, please turn over the page, my lords, where it is saying, my lords, the petition filed by the investigating officer seeking permission of the court to collect voice samples of the accused persons for further investigation lacks merit, and accordingly the petition is dismissed.
Yes.
Then, my lord, my learned friend, my lord, renews, and again, my lord, suffers a dismissal. Now, on count of that, my lords, please have, my lords, page 58.
Yes.
Insofar as, my lords, the contention of the learned defense counsels was taken into consideration, we humbly submitted that at when any voice sampling application is decided by a court of competent jurisdiction, it is imperative that the learned court peruse the case diary for the purposes of two things: whether compliance of section 5(2) of the Indian Telegraph Act 1885 as amended up to date, and the government circular issued in 1999 with a amendment of 419A and my lords, the rules prescribed thereunder pursuant to PUCL judgment by Puttaswamy are in compliance or not. That is, my lord, what is the soul of Jatinder Singh's judgment. Now,
Jatinder Singh notices Puttaswamy.
Yes, my lord. Kindly have, my lords, Jatinder Singh, my lords, immediately, lordships may kindly have para 63. Lords, if we have the same printout, but
Yes.
I have the SEC printout.
Yes, online.
If your lordships kindly see, my lord, para 62
Yes.
is in compliance, my lord, of actually, my lords, it starts from para 60. Though, my lords, I am relying upon another judgment of Andhra Pradesh High Court, which I will place on record. So, para 60, 61, my lords, reproduce PUCL landmark judgment. My lords, may I just make a submission here? It is not, my lords, about, my lords, Ritesh Sinha. Ritesh Sinha, my lords, there was first a judgment and order. There was a conflict between separate judgments and orders of two honorable Supreme Court judges. Honorable Justice, Madam Justice Ranjana Desai said that you cannot call for voice sampling in view of the bar under Article 20, subclause 3. So the matter was escalated to a 3-judges bench, that whether there is a bar or not, and whether the sample violates, therefore, the protections of 5th Amendment of American Constitution, my lords, covenanted in Article 20 to 22. That is, my lords, what the 3-judges bench, my lords, talks about.
Yes.
But insofar as, my lord, Jatinder Pal Singh, or, my lords, the judgment of Andhra Pradesh High Court, which I will read a couple of paragraphs, they are very clear that if the investigating authorities do not comply with the provisions of Section 5, subclause 2, read with 219A, then the very filing of application for voice sampling is non-est and is to be categorically denied. Now, if your lordships kindly see Jatinder Pal Singh, para 60.
Relevant paragraph.
Yes, my lord, may kindly see.
Para
So
60.
your lordships would be wanting to see Puttaswamy.
Yes. Notice in para 60.
Yes, yes.
Yes, I got it.
So
Yes.
62, my lords, is 419.
Yes.
That, my lords, came, the government, my lords, issued the circular pursuant to the findings of, my lords, PUCL.
Yes.
Now, your lordships would kindly see, my lord. Please see 63.
Yes.
As per Rule 419A of the rules framed under the Telegraph Act, the order of the Home Secretary granting permission to intercept telephonic conversations is to be forwarded to the review committee within 7 days of passing of the order for the purpose of being reviewed by the committee, my lord. This court does not find any material on record to establish that any review of the order of the Home Secretary was conducted in compliance of the aforesaid rules framed under the Telegraph Act. Therefore, this court is convinced that the special judge, while passing the impugned orders, has totally ignored the provision of said rules. Then, my lord, 64, this court is also of the view that as per provisions of Section 5(2) of the Telegraph Act, an order for interception can be issued on the occurrence of a public emergency or in the interest of public safety as per the law laid down by the Honorable Supreme Court in PUCL Supra.
Yes.
After the perusal of the records, this court is satisfied that in the peculiar facts of the instant case, the mandatory requirements laid down by law for placing reliance on such audio conversations have not been fulfilled. It is an admitted position that Rule 419A, Sub-Rule 17, which provides for destruction of intercepted and adopts said directions, court below while passing impugned orders has also ignored the settled propositions and directions of the Honorable Supreme Court, my lord. Then 65, my lords, reproduces Puttaswamy in terms of making, my lords, the rules mandatory. Then, my lords, pursuant to that, if your lordships now, my lords, come and, my lords, allow me to show the conclusion part in Jatinder Pal Singh. And my learned friend, my lords, read 81, subclause 4. Subclause 4 doesn't say that I am allowing these petitions on account of non-comparison forensic laboratory. The primary finding is driven on tape records of the calls intercepted in the instant case are not admissible since due procedure of such interception as mandated in the Telegraph Act and rules framed thereafter have not been followed. Rest is a sequitur.
Right.
Now, my lords, allow me to show a very, very interesting proposition, my lord, by my lords, Honorable Madam Justice G. Rohini, my lords, at that time in Honorable High Court of Judicature at Andhra Pradesh High at Hyderabad, then my lords at Chief Justice at Delhi High Court. I'll give a copy to my learned friend. This, my lord, is virtually, my lords, here, my lords, a writ petition was filed challenging, my lords, the sanction and order passed by the Home Secretary, my lords, granting interception, pursuant to which interception was done. And, my lords, all the voice sampling and everything was quashed. The order was declared null and void, primarily, my lords, on the violation of 5.2 and 419A, amended as in, my lords, 99 and sub-rules thereafter.
Yes.
Please have, my lords, for the first time, my lord, paragraph 7. So, my lords, 5.2 is, my lords, reproduced in para 6.
Yes.
That is, my lords, page 4. Now, 5.2, my lords, is a mandatory provision that in what circumstances can you tape a citizen of this country, my lord. Now, you cannot tape except in terms of rules 5, subclause 1 and subclause 2. Subclause 2, my lord, says, on occurrence of any public emergency or in the interest of public safety, the central government or a state government may, if it is satisfied that it is necessary or expedient to do so, in the interest of sovereignty and integrity of India, the security of the state, friendly relations with foreign states or public order, or for preventing to commission of offense for reasons to be recorded in writing. That is, my lord, reproduced in para 7.
Yes.
A bare reading shows that for the purposes of this and this, my lord, this, my lords, the occurrence of public emergency or existence of public safety interest are sine qua non. Now, my lords, 8 is reproduced, my lord. Then 9 is Hukum Chand. And 10, my lords, is the locus classicus, that is PUCL. The very purpose of, my lords, the Honorable Apex Court entertained is because, my lords, there were random, my lords, tapings going on.
Yes.
So therefore, my lords, sans and prior to the central government making a legislation, PUCL, my lords, Supreme Court brought, my lords, the relevant lines, my lord. Now, that your lordships will find, my lord, in paragraph 12. While taking note, my lords, at internal page 8, while taking note of the fact that no rules were framed by central government under section 7.2 subclause B of the Act, that is the precautions to be taken for the time being, we are laying the guidelines, my lord. So guidelines, my lord, are, my lords, para 1, 2, 3, 4, and up to 9, my lord. So, my lords, may kindly see page 9. On the right-hand side, third paragraph 9, there shall be a review committee, my lord. The review committee shall consist of, my lords, all these persons. And then please turn over the page at page 10, my lord, paragraph 13. Paragraph 13, my lords, reproduces, pursuant to the aforesaid procedural safeguards specified by the Supreme Court in PUCL, central government brought an amendment to the Indian Telegraph Rules 1951 by bringing in 419A.
Yes.
And, my lords, in that, my lords,
para 24 and para 34.
Yes, my lord. May kindly see, my lords, thereafter, all, my lords, now merits.
I read it.
Yes, my lord.
Yes.
Now, insofar as, my lords, paragraph 20.
Yes, I read it.
Yes.
I got
so, my lords, now, my lords, what are my submissions in reply? It is not about Multani. My lords, 1973 was the first judgment. Whether a tape recorded conversation, my lords, can be evidence before a court of law. My lords, we understand evidence before a court of law is, my lords, an oral opinion after taking oath or a document, my lords, which is produced and in conformity with section 62, going up to 65.
Yes.
So that is not, my lords, Multani does not, my lords, make my learned friend's request to have voice sampling, my lords, an automatic corollary. Does, my lords, Ritesh Sinha. Ritesh Sinha, my lords, talks about a different bar. That is, my lords, whether a right of silence and refusal is there. And it deals with that constitutional proposition. What, my lords, is to be seen is what is the law operating in the field. The law operating in the field is that, my lords, the permission cannot be granted by a court of competent jurisdiction unless and until there is not, my lords, compliance shown by the party who's asking this permission.
These are the procedural safeguard because it infringes the fundamental rights.
Absolutely, my lords. That is why
Safeguard, the procedural safeguard has to be strictly compliant.
Absolutely. And
as simple as
that,
that.
and my lords, in terms of review committee, my lords, may kindly see, my lords.
Mr. Naik, you just answer me whether it was placed before review committee or not. It boils down to that only. You file an affidavit. Tell the IO to file an affidavit. It was placed.
In terms of, my lords, I will fail.
It boils down to that.
But your
The
lordship, this is
procedural safeguard
with due
contemplated
respect, your lordships, this procedural
under
safeguard
5.2 has been complied or not.
Lordship, for a
If you
moment.
complied, then you have a case.
Your lordship may kindly come to paragraph 85 of the Pal Singh judgment. One more your time, your lordships.
Which one?
Paragraph 85.
85 of judgment.
The judgment which sir cited, there is paragraph 85, your lordships.
Jatinder
Andhra Pradesh or Jatinder?
No, Delhi High Court judgment, your lordship.
High Court.
Jatinder Pal.
Delhi High Court, okay.
Even otherwise, the prosecution has till date not advanced anything qua the genuineness of the voice recording involving the petitioner. In the absence of forensic analysis and report or other certifying instrument, particularly to the authenticity of the voice in question.
No, you have to see.
But
You
why
have
the
to
court is asking your lordship for the CFSL report if it is more.
see para 63 and 64. How will you
But
get over that?
This is the operating part of the judgment, your lordship. The court is saying that there is a requirement to send it to the CFSL.
You tell me whether review committee you have placed before review committee or not.
Lordship may put it in the order. I'll ask the IU.
No, why should I? You challenge. You are challenging. You have to satisfy.
It's your.
That is the precise ground by which the trial court is rejected. You say that it is placed before this thing and procedural safeguard has been complied with. That's what you have to say.
If your lordship passes a judicial order, I can ask the IU to file a affidavit, your lordships. Then.
No. I will not do that. I'll simply adjourn it. Remember it. I'll put it next week or whatever.
My lords may treat it as part heard, my lord.
Yes, it is parted. I spent so much of time then it's parted only.
Yes.
I've just put it after a week.
Considerable period of time on this.
इसके साथ रखेंगे.
What is the limited, your lordship?
And you give the compilation, proper compilation.
Yes, your lordships.
Please give the proper compilation.
Lordship, what is
after a week or so.
Yes.
What is the short point, your lordships?
Only you have to give an affidavit how you have this procedural safeguard contemplated under the that judgment.
But the IU will file an affidavit whether it was placed before the review committee or not.
Review committee or whatever. I will not advise you. Procedural safeguard.
An affidavit regarding, would your lordships have it on a specific date?
I will give it.
Yes.
4th February.
Lordship, Mr. Tanvir and me have appeared in 50 matters together and we have won all the matters, your lordships. 50 out of 50.
Okay. Next.
My lords, would your lordships have it, my lords, on 5th if it can be possible? Yeah, I'm more than grateful.
Lord, I'm
Which date
appealing for the opposite part number 1, madam.
Which date, your lordships?
Parted.
5th
5th February.
Yes, sir.
February.
Yes.
Extremely grateful, my lord.
I'm grateful.
Yes.
madam.
Next.
65.
65, my lord. The lordship, by the last order, had recorded the crux of the matter. And the state is to respond to this. Order dated 11/12/24.
Yes, sir.
Yes, my lord.
I have recorded.
Yes,
what is this case? Is
the 164 statement is there. Is against the present petitioner. Yes.
Oh, 164 statement.
Yes.
Okay.
Have you seen that last order?
No, my lord.
11, 12, 24.
No, my lord.
Just take-
I am not.
take it. What is the effect of those statutory committee's report? Because it is now a committee
Yes, ma'am.
created by the statute.
Yes.
What is the impact of that?
Your lordship taken up one chance, man.
Twice they had already taken time.
What?
Twice. This was the last occasion. Prior to
Last
that, there was another day.
There is a change of.
Yes.
That keeps
Last
on
time.
changing. On the next day, we don't know whether a friend would be here or somebody else would be there.
Entry order. Entry order.
My lord. My
Lordship may keep it next week, my lord, just because.
My lord. Obliged.
Good order.
Entry order to continue. Yes.
67.
Fixes it too. What?
Let us, and after 1 week, we will give it. Adjust it and give it. Yes.
Item 16 on behalf of it is just next week, my lord.
It is adjourned on request. Yes.
8.
Yes.
Hearing done. Petitioner challenges Miller. Cognizance as well as entire criminal proceeding on the basis that similar footing another co-accused Miller has been discharged and entire criminal proceeding has been quashed.
Ready?
No, it is the principal. So you take it other day. I will instruction what is the material specific against the present petitioner and
State council taking time. Adjourn. Entry mode to continue. Yes.
69.
69.
My lord, this is 69. Sambu. Sambu. Yes.
How many matters? 16.
No, my lord, my lord.
No, 69. How many matters? 1. Okay. Yes.
May I submit, my lord?
Yes.
My lord, in this case, the notice was issued. My lord and friend has appeared. My allegation on 3 points, my lord.
What are you seeking here?
My lord, quashing of cognizance.
Okay.
That at 13/4/23. My lord, kindly page 39.
39.
Yes, sir.
Okay. Yes. Yes.
My lord, the learned JMFC has recorded the statement and thereafter take the cognizance. That order shows. But there is no statement recorded on that date, my lord. No statement has been.
No, just see page 38 is written.
Page 38.
21/3/2023.
The statement
The
was
complainant Devraj Naik is present today
Yes.
before this court.
That is at page
He is
38.
examined
Yes,
and
ma'am.
discharged.
Yes, madam. That is at page 38. That is the order dated 21st March 23. My lord, the order dated order page 39.
His
Please.
statement is recorded under 200
Yes.
CRPC.
Again, the statement was recorded, which is false. Statement was recorded. My lord, my paragraph 6 of my petition. I have clearly.
You say that the proceeding is written, but no statement is.
No statement has been recorded.
What do you say?
My lord, in this case, my lord, the 4 witnesses has been examined in the trial court, my lord. 4 witnesses examined, my lord.
That is
By the trial court, my lord.
I am
The
sorry.
offense against my learned friends is a very serious, my lord, nature, and for which, my lord.
Answer it. The seriousness will.
My lord.
Whether on 21st March 2023, statement of Devraj Naik was recorded or not?
Recorded, my lord. Because
My lord, I will ascertain whether, my lord, my friend saying.
I am submitting that
statement.
I am submitting.
Yes.
On 21st March 23, that recorded, the statement was recorded, my lord.
Yes, then?
My lord, the 13/4/23. The
13/4.
learned JMFC again recorded the statement, which my lord can 38,
The
39.
complainant, namely Devraj,
Yes.
and the witnesses, namely so and so, so and so, so and so. So and so.
Again, they were examined.
This court and the counsel for complaint file Hajira and behavior. Complaint namely Devraj is examined 200 CRPC.
ସେଠି PW ଯୋଉମାନେ ହେଇଥିଲେ ଏଠି PW ଅଲଗା ପୁରା ଚେଞ୍ଜ ହେଇଯାଇଛନ୍ତି ସେଠି PW ଦେବରାଜ ନାୟକ PW1 ଏଠି PW2 ସେଠି PW6
You say that Devraj is examined twice.
Not at all, my lord. On 13/4, no statement has been recorded. It is non-application of mind, my lord, of the law and JMFs.
No, my lord, that is the 4 witnesses has been examined, so my information is concerned, my lord. Whether the Debraj, my lord, my friend is saying whether Debraj has examined on the very same day, my lord, I have to ascertain whether
What he's trying to say is, just understand. He says on 31st/3/2023, court records that Devraj is the complainant, his statement is recorded. It's all right, no problem.
Under section 200.
200.
Amen.
It is recorded, no problem. Again, on 13/4/2023, the trial court again writes that Devraj's statement is recorded today.
My lord, I have not done.
And
That is the first
so
time.
200 statement is recorded twice.
No, my lord, the so far
Or partly recorded on that day, partly recorded on this day.
Not after examining the Devraj, my lord, complainant, informant with that, my lord, that they have annexed, my lord. Once they have, my lord, to examine. How, my lord, last occasion also kind of a class, my lord, remember lawsuit, my lord, what they have stated, 25/9/2024, my lord. The allegation against them, they put, my friend put a question to me, my lord, that I have the informant, my lord, in this case, my lord, that I myself and others, my lord, sold the property of the mortar, my lord.
Merit, don't go to merit. I'll go to merit later on.
My lord,
he says that it's a case of non-application of mind.
No, my lord,
I'll set aside the.
No, my lord, that I have to ascertain with the once, my lord, he has examined, my lord. My lord, also as he has annexed, my lord.
Ascertain it. Ascertain. Please. Yes. Ascertain it and
that argument, my lord, advance, my lord, that's the statement, my lord, that they are twice examined, my lord.
Because he doesn't have a case on merit, so therefore he's taking harping on.
Losses put last together, one the time he had.
Verify. It may be a typographical error, maybe partly it is recorded, secondly it is recorded.
My lord,
Just verify.
my lord, the case has been posted to 18th.
Not so that.
18th, 16th. That may be, I shall file petition, that will be additional.
No, what is the stage?
Because my
4 witnesses already examined.
my lord, after my lord's
At this stage, my lord, he's saying the first time, my
Not
lord.
say it. These are very minor typographical error, maybe typographical error.
that is true.
He might have written along with the other witnesses. He written the name of.
Again examine as per his record, but there is no statement of those witnesses. There is no statement.
You have statement against the court.
No.
The court has done and written the.
Ownership, my lord. I am not exposing my lord.
No, I understand it, but
that is the order.
then it has to be record has to be called for. Just check it up and tell me to that. Yes, simply urgent. Yes, next.
My lord,
70.
my lord, on 16th, the case has been posted there at
16th of February.
This month.
Tomorrow, then what can be done?
I shall file petition that will be adjourned to next.
Only, my lord, it will
be
finished, my lord.
What 3 witnesses have been already.
I am there. I was present there.
It's all right. One more witness will be examined. How does it make difference?
Yes, let him.
Once it's stayed, I know what will happen thereafter. Yes, next.
70.
First of all, you should have come a little early.
My lord, I would have come early, but it was not listed, my lord. I have to find.
Yes, next.
70.
Wait, please, your lordship.
My lord, shall I file petition there?
You
my lord has filed order. My lord has earlier previous. My lord has filed interim order. My lord, I shall file it. Will be allowed.
No, it will not be allowed. It will not be allowed.
No, my lord's order, my lord.
It's there already.
Oh yes, previously when the notice was issued.
If it is there, it will continue.
It
Yes,
will
next.
Yes,
70.
Yes, may it please, your lordship.
It will come.
In this matter, your lordship previously heard this matter, my lord. Initially, your lordship, the petitioner forwarded, and after that, my lord, the past charge sheet submitted on 8/8/2022 against 6 number of accused person and keep the investigation open under 173(8) of the CRPC, showing the absconder accused. One is Asgar, my lord. Since then, my lord, after 2 and 6 months, they filed charge sheet after filing of this CRMC. I approached before the learned court below under 167 subsection 2 for default bail. They denied on the ground that I have 10 number of criminal antecedent. Thereafter, I filed this CRMC. After that, they submitted charge sheet against me, my lord.
We'll take instructions of whether I made a prayer for the time to extension of the time for the file the charge sheet through PP or not. This is the very important.
No.
Your lordship kindly.
No.
I will take instruction.
Let him see.
We'll take
My lord,
instruction.
since last
Whether
6
whether
days.
whether
very
IO has
important.
taken extension of time.
No, my lord. Every order sheet is there with your lordship's board, my lord.
Let him verify.
Yes, my lord. I will take instruction on that part.
My lord, since
On
last.
the ground, in the ground of criminal antecedent,
My lord.
the statutory benefit of 167(2) cannot be declined.
No, I am not that. I am that whether the IO made a prayer or not for the
Verify.
extension of the time for
Admittedly, charge sheet was not filed against him.
Yes. I will take instruction.
Every, my lord, every day since April, my lord, every day they are taking. I will take instruction whether charge sheet submitted. I will take instruction whether filed petition.
Last and final opportunity, the state council is granted one more opportunity to seek instruction in the matter whether the IO had moved application for extension of time for filing charge sheet. The petition.
My lord,
there is clear ground, my lord. They not submitted any charge sheet.
Disputed. I am not disputed on that part.
Last 2 years, 6 months after filing of this CRLMC, they filed charge sheet, my lord. That is only there.
And another question is, if the preliminary charge sheet is filed, your name is there in the FIR.
In the FIR. But in the preliminary charge sheet, they have not stated
this
that.
Also, you just get ready.
Yes.
See, in the charge sheet, his name was there.
In the FIR.
You filed the preliminary charge sheet. You have not taken his name.
Yes.
Okay. Thereafter, after the statutory period, you file the supplementary charge sheet. Subsequent charge sheet. In that charge sheet, you bring his name. So whether he can get the benefit of 167(2).
I don't know. I will take on that part.
If his name would not have been there, it's a different story.
Yes.
His name was there. In the first charge sheet, you exonerated him. You have not filed charge sheet.
My lord.
A specific.
So therefore, 167(2) benefit can be given in this circumstance.
Yes.
A short date may kindly be given, my lord. Since last 3 years, he is in judicial custody, my lord. The quantity is 29 grams, your lordship.
Yes.
Grateful.
Habitual offender.
They are saying habitual offender.
Habitual offender is not a ground for 167(2).
They never recovered any contraband substance from me, my lord.
He has a case
In any
on
of the cases.
167(2) only. Not beyond that. Yes.
I am not on that.
Yes.
Grateful, man.
Yes.
Well, in this case, I am challenging the order of cognizance passed by the Lord JMFC Bhubaneswar, dated 11/9/2023, madam.
Yes.
Well, actual my case is the complainant has issued a we have paid a fund-based loan by page 52, madam, and of 4 lakh. They have undertaken that we will refund them by 31st/12/2020 with 8% interest. It comes to 5,60,000. On that day, they have not paid the sum and issued a check. Though they have not paid the amount, for that reason I filed a 1cc case before the non-JMFC Berhampur, minor, which is pending, and before the White Annex 2, minor. In the meantime, to counter the same, they have created I was working as a foreman in the organization of the complainant, minor. They have allegation filed this case that I have misappropriated the money and sold stolen the property, everything. In order to counter my case, minor. And they have issued acknowledgement.
Is it a public sector undertaking?
Minor.
Two.
Others Nobel Corporation Limited, minor.
Yes. Yes.
Somebody has appeared in this case, but they have taken the stay order, my lord, in my case, in CRLMC number 1578 of 23, my lord. On 9/5/2023.
That's pending. That's pending in this court.
My lord. And since then, my
Please
case is
brief this matter along with give the name.
CRLMC 1578 of 2023.
Give the title also. Yes.
Madam, my prayer is I may be my proceeding pending against continuing my against me in goodness or my lord.
No, see, prima facie, if you want that, then prima facie case is made out. There are allegations against you. Whether it is counterproductive of your complaint or not, that has to be tested.
Right.
Then let us see the copy of get that matter also. Tag with this. Let us see. Yes.
Date may kindly please.
Yes. Next. 72.
72.
Let I pray for an adjustment, man.
On request.
3 minutes to continue, madam. So I am appealing for the information.
Yes.
Number 2.
Joint request. Yes.
73.
Adjournment.
Adjournment.
But I am for the opposite party. Now the trial has about to at the end. 6 witnesses have has already been examined, and also the accused has been his evidence has been recorded. Now he has paid for quashing of the quashing cognizance and proceedings.
When the cognizance was taken by the court?
My lord,
2019.
19, my lord, 19.
I think there is virtual completion.
Also see the evidence of all the witnesses, they have already been examined.
Case of purely civil and case.
That's right, but evidence is the.
All the witnesses they have already been examined.
Has given a direction to
That's
the.
right, but evidence of witnesses have already been recorded. 6 witnesses have been recorded.
Yes, my lord. And accused statement recorded, my lord. Now the question for evidence of the accused.
Oh, then you should argue all this point there. Right? I can't scuttle the trial like this. At the fake end.
Fag end, my lord, yes.
My lord, today I am not feeling well.
Tomorrow, come tomorrow.
For that.
Fake end of the trial, how can I interfere and quash the cognizance, you tell me?
Interim order we can continue.
For tomorrow, till tomorrow, it will continue.
My lord?
Tomorrow.
Tomorrow, my lord.
Monday. This has to, interim order, there is there an interim order?
Yes, my lord.
This is very unfortunate. You challenge the cognizance order when the trial is concluded. Accused statement has already been recorded.
Yes, everything is
At this stage, how can the trial can be scuttled like this? Whether civil nature or whatever? It can't be like this.
My lord,
Can't be like this.
let it come in 22. 21 or 20?
21, yes, 21. I'll vacate the stay order.
Yes, vacate the stay order.
I'll vacate the stay order.
And the trial is held up because of the remote.
74. 74.
Lord, I'm on behalf of Mahapatra is not well. He's with opposite party. Taken up next week. Next week.
Mr. Mahapatra. Deepak Kumar Mahapatra.
I have a request.
Yes.
Let the State Council be directed to obtain both the case records for appreciation because it is related to each other. There is a case and counter case. So far, this present cognizance order is concerned, it relates to SCST Act. And notice was issued. My friend said that case record is necessary, police record.
You just check it.
Obtain both the cases.
Yes.
75.
My lord, I am for the petitioner, my lord.
Yes.
Last two did informed advocate taken time. It can be compromised. But informed advocate today tell me he is due to train vehicle he not come in time. So kindly taken up next.
Request on request, joint request. Yes, next.
76.
Lordship, in item 76, I'm praying for an action.
Yes.
Lordship, interim order is there, Lordship.
Notice is sufficient, but none had entered appearance.
Lordship,
In the
interim
minutes
order.
of justice, yes.
77.
Yes. May I please your lordship? Your lordship has directed to.
77.
Persons to the direction. They paid 3.
There is a IA for stay, my lord.
The counsel for the CD for the case has not yet been obtained by the State Council, hence he seeks an adjournment to publish the matter in the interim order to continue.
78.
Please, my brother also instructed me, let the matter may be fixed on 27th of 28. Let's collect the deposit the money.
The settlement out of 2.7 settlement what is made.
Yes, my lord.
You pay the entire amount, so take it up in any other
When?
29 or 30. Lord.
20?
29 or 30. Lord.
29. Yes. The
30.
councils appearing for both the parties conjointly submit that the matter has already been settled.
We'll pay the
And
amount.
settle at what
2.70, 2,70,000. So he's agreed for
the opposite party has agreed. Opposite party has agreed.
Yes, as for the petition, he is opposite.
Petitioner has agreed to pay 2.7
70,000.
7,000.
70.
70 lakh to the opposite party as a full and final settlement.
Yes, sir.
And counsel for the opposite party agrees to the same. leaves the matter on 29.
Entry what continue?
Entry what?
20
Finish that. Okay. And that is 2,70,000.
2,70,000.
May I please, my lord? The limited grievance of the petitioner, my lord. 311 petition has been rejected by the court below. 311, my lord. I want to examine, my lord. PW 1, 2 and 6, my lord. 76, my lord. And POSCO 3 of SCST Act is there, my lord. PW 1, 2, 3, my lord. Mother, a victim and father of the informant in this case, my lord. But lower court rejected the petition. Again, that petition has come.
Where is the application?
My lord, this annexure 7 is the impugned order, my lord, rejection, my lord. Annexure 6, my lord, the petition filed before the court below by the public prosecutor.
PW1, who is PW1?
PW1, my lord, is the victim, my lord, minor girl, my lord. PW2, my lord, is the mother of the mother. And PW6 is the father.
One ruled out, 2 and 6. One opportunity. And petition is agreed by the order dated 8/11/2024, whereby his application under section 311 CrPC has been rejected. The petitioner is accused in the FIR number so and so and facing trial. And the charges has been facing trial for alleged offences. Punishable under section. What are the charges? 376 2N and 363 oblique 376 2N section 4(2)(6) of POXO Act. POXO Act. And 32V and of SCST COA. Petitioner has moved the application under section 311 CrPC on 4/11/2024, seeking recall of PW1, 2 and 6. PW1 is the victim girl, minor victim girl, whereas PW2 is the mother of the victim and PW6 is the father of the victim girl. Questionnaires कुछ नहीं है, कुछ भी नहीं. When were they rejected? What are the grounds for rejection?
In a general terms, it has been stated at page 27. Regarding the caste and the date of birth of victim, when those two need to be examined.
The trial court rejected the application inter alia stating agent. Para page 3, page 30. Last round. Let also for the petitioner submits that one opportunity to cross-examine, further cross-examine these witnesses would suffice for him as he is facing serious charges. Section next part of section 33 type of POXO Act, there is a provision for repeatedly calling the minor witnesses. Therefore, recalling of the PW1 with the minor in the present case is not has been rightly rejected by the trial court. Insofar as PW6 and PW2 and 6 are concerned, and the petitioner submits that one single opportunity may be afforded to him to further cross-examination regarding it to the statement in the bar and the reasons for the application. I'm inclined to allow the application under 311 CR, which is the petitioner, insofar as the PW2 and 6 are concerned, and the trial court is directed to fix a particular date for a singular opportunity to the petitioner to further cross-examine these two cases. Before cross-examination, before the date of probability is directed to furnish the proposed questionnaires to put to the said witnesses in the trial court to examine and the relevancy of those questions to be put to the It is made clear that under no circumstances the petitioner shall be detained to seek adjournment in this matter, and we should conclude the cross-examination on the date to be fixed by the trial court. Yes, yes.
Obliging lords.
You are the informant.
My lord.
You should have told me, na?
No, my lord, I have mentioned my lord everything.
I am giving dictation. I thought that you are accused. You have moved the application.
I'm a government public prosecutor moved the bill application, my lord.
What?
They are my lord moved, my lord.
People are hopeless. I have given dictation. You are jolly well hearing.
No, they have moved.
Change everything now.
No, they have moved, my lord. They.
Please go there.
Public prosecutor, they have moved, my lord.
But I gave dictation.
My lord,
you are hearing it. It will clarify.
Petition informant, my lords. I'm sorry, my lord.
Petitioner, the informant in the case. I am saying that you are facing serious criminal charges. You are hearing.
They have moved, my lord. I'm sorry, my lord. They have.
Then I have to issue notice to the accused.
No, after last occasion, lordships.
I have to issue notice to the accused. Behind the accused. Whoever it is. Where are the accused? Because they are right to challenge. What is this? You have not implemented them also.
My lord, they have my lord feelings, my lord.
Have you realized the implication? 311 application moved by the prosecution, it was rejected. You are the informant challenging that.
My lord.
This much you have not told me. I thought you are accused. I am giving dictation.
No, my lord, I'm committed, my lord. I forgot, my lord. That.
And you have not implemented the accused also.
Because the lower court, my lord, government also not implemented, my lord. They have moved the application. They have not made the party.
Shall I tell you all these things? Substantive right of accused is involved.
Only my lord exam, they will cross examine, my lord. That is,
I don't know.
They will not prejudice, my lord. They will not prejudice me in any manner.
Counsel for the petitioner seeks leave of this court to implead the accused person as opposite parties. How many accused are there?
One, my lord.
Opposite party number 2. Let him do so within a week. Issue notice to the newly implemented opposite party number 2. Leave the matter. Yes.
My lord, come to before Hon'Ble High Court, but they have not come. Informant being the my lord father, I have come, my lord.
Next slide.
80.
But just now, my lord, I am permitted to read, my lord.
No. Now all are equal. You have to find it there. Yes. These are minimum thing. Why can't you do it all this? I don't understand. Whether accused will be prejudiced or not, the accused will tell or you will tell. He is facing the trial for such a serious offense. Therefore, I thought you are an accused. So therefore, I gave one opportunity.
In the last occasion, my lord, also given my lord opportunity.
Why are you wasting? You implead the accused.
Last occasion,
witnesses cannot be recalled in the absence of accused.
Na apna last occasion notice दिया है दिला तांको जे तम take instruction मिला. Do you agree?
Implead. Your petition is default. Defaulted petition. You should have impleaded the accused. Yes. After impleading, issue notice, he'll come and whatever happens thereafter. Yes. Yes.
Number 80, Your Lordship, heard this matter previously. Our argument already closed, Your Lordship. In 172, Mr. Das is appearing. In 199, I am appearing. We both engaged Mr. Kanungo, sir.
In fact, 5 petitioners are there, my lord.
There, my lord.
And four set of lawyers representing different petitioner accused lords. So for Mr. Milan Kanune's case, he appears for the 2 accused persons. First one.
Yes.
Mr. Bosco appears for one thing, but when Mr. Mohanty appears for the contractor, my lord, in that application, my lords, that condonation or delay petition has not been, that formality is not.
But in any case, I have to hear it. I have forgotten what.
No, in fact, we hold your lordship in high esteem, but because of taking off so many matters, but this honor court is do not taken as a granted that remember lordship remembers everything.
It's very difficult.
And it's I mean, in fact I appreciate.
And I tell you,
in fact sometimes I admire my lords. I also deal with number
70% matters are filed very casually.
And
very
in fact,
casually, without any.
when note of submission copies are given to me, my lords, I mean, they introduce new grounds. They introduce
New grounds, they just reproduce the petition copy and file.
Expect to do everything.
Exact same petition copy, written submission. Exact same petition. Copy paste, written submission. And already there petition, I can't read it what. And when I reserve the judgment, then I realize the problem.
And in fact, I admire my lordship remember so much of things.
What to do? Again read and do it. That's the problem.
In fact,
Assistance level is
not in all cases, a lordship is expected to remember whatever the arguments, whatever the grounds.
not possible. That's the problem. What do you want now?
My lord, so the two cases concerned, if learned counsel wants to admit the submission.
It can't be part of my
no piecemeal.
Then my lord, every day they are taking time.
No, I'm not taking
Yes,
time.
your lordship.
No.
Yes, your lordship. Your lordship, only this honorable court, my lord.
Now,
Only this honorable court.
Rather, I have made
Mention the life streaming, your lordship.
My lords, one thing.
I have the copy of life streaming, my lord.
In number of matters, I mentioned that should taken out 2 p.m. At least 2.
Every day, sir. Every day, sir.
No, that's not correct.
Live streaming is there.
Yes, I have got my own timing. So you asked your friends. Even before you also, I made a mention that should have taken out 2.
No, sir.
Not twice I have made mention.
He will
I'm also
give it
interested.
give it date.
My
Give it. Okay, thank you.
specific, my lord, in others matter, delay may kindly be condoned, your
We'll
lordship.
see.